Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in Case 18-1447, Republic of Hungary versus Simon. Mr. Silbert.
Mr. Chief Justice, and may it please the Court, comity-based abstention proceeds from a simple premise that this Court has recognized since 1885. When a complaint alleges that foreign parties harmed other foreign parties in a foreign country, a federal court can decline jurisdiction in favor of a foreign tribunal. In this case, plaintiffs allege that Hungary took property from Hungarians in Hungary during World War II. The United States long ago settled its claims against Hungary for wartime property confiscations, yet plaintiffs ask an American court to apply American law and impose economy-crushing liability on another sovereign nation for conduct in the sovereign's own territory that harmed its own nationals more than 75 years ago. If the shoe were on the other foot, and the United States faced analogous claims in a foreign nation's courts, the comity grounds for dismissal would be clear and undeniable. Those grounds are every bit as strong when the United States orders Hungary to submit to the jurisdiction of an American court. If these same plaintiffs had sued private defendants for aiding and abetting the same property confiscations, their claims could be dismissed because of the risk of international friction. Plaintiffs say this case can't be dismissed only because they sued sovereign defendants under the Foreign Sovereign Immunities Act. But for three reasons, that can't be right. First, the FSIA's plain text tells us that it concerns only sovereign immunity from jurisdiction. It has no effect on non-jurisdictional prudential doctrines like comity-based abstention. Second, the FSIA says that when sovereign defendants lack sovereign immunity, they should be treated the same as private defendants, not worse than private defendants. And finally, the FSIA undisputedly leaves in place other prudential grounds for declining jurisdiction, like forum nonconvenience, and there is no textual or other basis to treat comity any differently.
Mr. Silbert, I want to pick up on that very last thing you said, but look at it from a different perspective. What independent role do you think international comity plays, given the fact that you already have, where there are unchallenged forum nonconvenience grounds and active state grounds? What is the independent significance of international comity?
The international comity doctrine applies in different circumstances than FNC and active state, and it serves different interests. The forum non-doctrine in particular ultimately serves objectives of convenience and the practicalities of litigation. The interests served by the international comity doctrine are quite different. They go to the...
Well, you talked about, this case involves Hungarian citizens suing Hungary for events in Hungary. Those sound like considerations a court would take into account under forum nonconvenience.
They might be, Your Honor, but the D.C. Circuit held in this case that the FNC doctrine does not apply. We think the international comity doctrine clearly does apply, and even if they did happen to apply in the same cases, they do serve different objectives because the comity doctrine is not ultimately about questions of convenience or practicality. It's about the dignitary interest that each sovereign has when it has a competing claim to jurisdiction.
Thank you, counsel. Justice Thomas?
Yes, thank you, Mr. Chief Justice. Counsel, perhaps a somewhat preliminary question and a bit different from the Chief. If we reverse in the following case in Germany, hypothetically, what should we do with your case?
Well, Your Honor, you could then hold that there is no jurisdiction in this case and vacate the D.C. Circuit's decision. You also could go on to decide the comity question, as this Court's decision in Sinechem and in Levin against Commerce Energy make clear. And under the circumstances, I think it would be useful if this Court did go forward and reach the comity issue, because that is a question that has divided the lower courts, and there is substantial confusion about when comity applies and how it applies, and I think the lower courts would benefit from guidance from this court.
So if we do not think, for example, if I don't think that comity existed pre-1976, do you think we have the authority to just create a doctrine such as that?
I think you have the authority to do it, Your Honor. I understand that this court has not created common law doctrines like that very much recently. I do think it's clear that the comity defense that we're asserting did exist prior to the enactment of the FSIA. It's discussed explicitly in the Belgian Lind. It's discussed in Canada Malting. Justice Scalia's dissenting opinion in Hartford Fire discusses the doctrine at length. Justice Breyer's concurring opinion in Kiobel and Justice Sotomayor's dissenting opinion in Jesner all talk about this.
Wouldn't that take us I'm sorry, Tom, I just want to get this in. Wouldn't that get us back to where we were pre-FSIA and on having these decided on a case-by-case basis?
It wouldn't, Your Honor. The problem with the pre-FSIA regime was that sovereign immunity determinations were left to the executive, and the executive was subjected to political or diplomatic pressure in individual cases. The comity doctrine that we're asserting is easy for courts to apply, and it demands nothing from the executive. The courts start by asking a simple question. Does this complaint allege that foreign parties harmed other foreign parties?
Thank you, counsel. Justice Breyer?
I'd like to pick up on that last question. One, as the Chief, I think, brought up, how do we know that comity is a separate doctrine rather than, say, a motivating principle underlying a bunch of other doctrines like foreign nonconvenience and exhaustion and sovereign immunity and abstention? And if it is a separate doctrine, what exactly does it consist of? Do you prefer the Ninth Circuit, which has 5 factors? Stryker and Lee, who are good international law professors, suggest 4 factors, and maybe you have some other factors.
Well, I think Your Honor first is correct that principles of comity find expression in a number of different doctrines of U.S. law, including sovereign immunity and active state. There is a separate and distinct comity-based abstention doctrine that this court recognized as far back as the Belgian Lind, and it's clear that the application of that doctrine did not depend on factors of convenience or practicality, because this court in 1885 said that courts look to motives of international comity, and those principles are simply different than the interests that FNC serves. As to how to apply the doctrine, again, I think first the court should ask, is this a case alleging that a foreign party harmed another foreign party? And if it is, then I think comity-based abstention may be available, and I think a court should then ask the question that you asked, Justice Breyer, in your concurring opinion in Kiobel, and that is there nonetheless a distinct American interest in the controversy that would justify the assertion of jurisdiction? And if there is, I'm sorry, Justice Breyer, were you asking a question?
No.
Okay, so I think, again, in a case where a foreigner harms another foreigner, there is a comity interest that may warrant abstention, and the court then asks, is there a distinct American interest that would justify asserting jurisdiction here? If there is, then a court may exercise jurisdiction, but in this case where there isn't, a court should decline jurisdiction and abstain so that the sovereign that has the paramount interest in the controversy can address it under the framework of its own legal system.
Justice Alito?
Section 1606, on which you rely, makes a foreign state, quote, liable in the same manner and to the same extent as a private individual under like circumstances. Your friend on the other side says this concerns substantive liability rather than threshold federal common law defenses. Why isn't that a reading that's more faithful to the statutory text?
So 2 answers, Justice Alito. First, we think we would win on the statutory text even if Section 1606 were not in the statute just based on the language of 1605, but I do think that Section 1606 helps us, and it helps us because it refers not only to the extent of liability, but also the manner of liability. And so, for example, if a private defendant would not be subjected to class action liability in a U.S. court, then a sovereign defendant should not be subjected to class action liability in a U.S. court, because that is the same manner of liability. And I would also note that my friend has no textual explanation for why the forum non conveniens doctrine survived the enactment of the FSIA, because like comity-based abstention, FNC is another common law doctrine that permits a court to decline jurisdiction. And so if that doctrine survives, then I think comity-based abstention also must have survived.
One other question. If we were to rule hypothetically, and this is just hypothetical, that in favor of Germany on the jurisdictional issue, wouldn't the plaintiffs in this case still have an argument based on their claim of denaturalization?
I don't think so, Your Honor. I think if that argument had merit, then it would apply in every case where the plaintiffs in the next case would assert that there is jurisdiction. In other words, if the domestic takings rule does not apply in instances of genocide, then I believe the argument that my friend makes that the plaintiffs here were stateless persons would apply in every such case. So,
right, thank you, counsel.
Justice Sotomayor?
Counsel, I don't understand how, if in the following case, hypothetically, we were to decide there's no jurisdiction, what power would we have essentially to give an advisory opinion on this international comity doctrine? I thought no jurisdiction meant just that we don't have the power to decide anything.
Well, Justice Sotomayor, this court held in Sinachem and again in Levin that a court can dismiss on threshold comity grounds without first determining that it has subject matter jurisdiction. That was the...
Counsel, I understand that principle, but this is something different. We have already decided we would have already decided we had no jurisdiction. So having made that decision, how would this become nothing more than an advisory opinion?
I think, Justice Sotomayor, you certainly could then hold that you have no jurisdiction in this case and vacate the Court of Appeals decision.
One final point. As I read the record below, it appeared that this prudential international comity doctrine was not really the focus of your argument and briefing. It seemed to me that the focus was on that respondents had to exhaust their remedies. What you've raised before us seems like a very different tact.
Well, I think in the circumstances of this case, Justice Sotomayor, they amount to the same thing. Our point is that because of principles of comity, these plaintiffs should first assert their claims in a Hungarian court. And because they first asserted them in an American court, the American court should decline jurisdiction and the case should proceed originally in Hungary. I think whether you call that an abstention principle or an exhaustion principle, the point is that Hungary should have the first opportunity to address these claims.
But you did use the word exhaustion. Thank you, counsel.
Justice Kagan.
Mr. Silbert, you've referred a couple of times now to the historical basis of the comity doctrine. There's an amicus brief by Professors Dodge and Gardner that takes you on that, and that says that all the various cases that you've cited fall into one of two categories. Some are immunity cases, and some are forum nonconvenience cases. And that there's really no historical basis for this separate international comity. So I think I'd like you to respond to that brief.
Well, if you look at the Belgian land, Justice Kagan, which was this court's decision in 1885, it says two things that directly refute that position by Professor Dodge and Professor Gardner. First, it says expressly that courts decline jurisdiction in cases between foreigners out of motives of both convenience and international comity. So those are two separate doctrines. But even more to the point, it says that in some cases, before exercising jurisdiction in cases involving foreign interests, federal courts would seek the consent of the consul of the foreign nation with a competing claim to jurisdiction. And clearly, that foreign consul was not providing an opinion about matters relating to the convenience of the parties. What the foreign consul was telling the courts was whether exercising jurisdiction in a U.S. court would be an affront to the dignity of the other nation with a competing claim to jurisdiction. That is a comity interest, not a forum non-conveniens interest.
You're pointing me to Belgian land as your best case? That's the one I should read?
I think the Belgian land is clear on that subject. We've also cited two district court cases.
Okay. If I could just go on.
Please.
You said we're not going back to the old immunity doctrine, the one that was supposed to have been displaced by the FSIA, because that was executive-driven. But I would think the fact that it was executive-driven would cut the other way. At least the executive knew something about foreign affairs and were politically accountable. And it seems like much of the unhappiness about that doctrine had to do with the fact that it was a kind of kitchen sink approach and nobody could predict it. And isn't that what you're asking us to replicate?
Well, we're not, Justice Kagan. We're not asking federal courts to make any kind of foreign policy judgment. What we're asking the courts to do is to do what this court did in Sosa, in Kiobel, in Jesner, in R.J. Nabisco, in Empegran, and a number of other cases, and that's simply recognize that when a lawsuit asserts claims by a foreigner against another foreigner, especially for conduct in a foreign country, there is a risk of international friction.
Thank you, counsel. Justice Gorsuch?
Counsel, that's exactly where I wanted to go, which is, prior to the FSIA, we did have what this court has described as bedlam in a multi-factor balancing test on the convenience of the parties is one thing, but also international friction and a sense about foreign dignity and all that, which, as Justice Kagan pointed out, was channeled through the State Department. And here you're asking us to do it directly. And I guess I'm still struggling with what's the difference between the regime you'd have us create and the regime that Congress clearly wished to displace because it was producing, quote, bedlam.
Well, in the regime that Congress displaced, the executive was forced to make foreign policy judgments. In the regime that we are proposing, the courts would avoid making foreign policy judgments by recognizing.
I thought you said we should be concerned about friction, for example.
Well, I think the courts can recognize the kinds of cases that would cause international friction.
Isn't that a foreign policy judgment?
It's not, Justice Gorsuch. I think my friend is asking you to make.
Let's say I disagree with you. That sounds to me like a foreign policy judgment. Then what?
Well, if a court accepted jurisdiction in this case and extended U.S. or D.C. common law to apply in an international context to regulate the conduct of foreigners or foreign sovereigns harming other foreigners in a foreign country, that is a foreign policy judgment. So if you think my rule is a foreign policy...
Yes. So what do we do on a separate but related matter, which is normally we assume that when Congress dictates that we shall hear certain classes of cases, that we have a duty to hear those certain classes of cases. And we can't decide not to do it just because it would be inconvenient to us.
Well, that is the general rule, Justice Gorsuch, and this court has recognized discrete exceptions. And one of the exceptions, as set out in Canada Malting and in the Belgian Lind, is that courts have discretion to decline to hear controversies between foreigners.
Thank you.
Yes.
Justice Kavanaugh.
Thank you, Chief Justice, and good morning, Mr. Silbert. On your point that it's easy for courts to apply this, I hear you giving us something of a bright line, that if it's foreign defendants who injured foreign plaintiffs in a foreign country, then abstain. that accurate?
I think if there are no other relevant facts and circumstances, then yes, Justice Kavanaugh.
Okay, well, what could be other relevant facts and circumstances?
Well, let's say, for example, the controversy concerns a discrete piece of artwork, and that piece of artwork is hanging in a gallery in Washington, D.C. And let's say if the possessor of that piece of artwork gives it back to the wrong party, that U.S. party could become liable. Then there would be an interest in a U.S. court hearing the dispute, and maybe that interest is sufficient to override the foreign interest.
How do you see this playing out in the Hungary courts?
Well, the plaintiffs would file a civil action as they would in any normal case. Hungary has waived by constitutional amendment any statute of limitations to these claims. They would file claims under, we believe, the Hungarian Code of 1959, which was the first codified law in Hungary and which applies to causes of action that accrued before its enactment. The claims would be Hungarian versions that are similar to the claims they've asserted here, like for property loss or unjust enrichment, and they would go forward and litigate their claims like any Hungarian plaintiff.
And you say in your reply brief, if they think they were treated unfairly in the Hungarian courts, they could go to the European Court of Human Rights. Is that accurate?
That is accurate, Justice Kavanaugh. If there was a violation of the rules set out in the European Convention of Human Rights, like the rule under Article 6 to a fair trial by an impartial tribunal, then the plaintiffs, after exhausting Hungarian remedies, could apply for relief to the European Court of Human Rights.
Thank you.
Justice Barrett?
Good morning, Mr. Silbert. So you told Justice Sotomayor when she asked you about the distinction between exhaustion and the comity doctrine that we're talking about this morning, that whether you call it abstention or exhaustion, it means you go to Hungary first, that they're functionally the same thing here or they're very closely related. But if these plaintiffs had exhausted in Hungary first, I gather from your answer to Justice Kavanaugh that they still could not come here, that the doctrine of international comity that you proposed would still be a bar. Is that correct?
Well, I think they could come here and seek relief like any plaintiff who had litigated in a foreign court could, and whether the U.S. courts would recognize the foreign judgment would be controlled by the principles set out in the Restatement of Foreign Relations Law at Sections 483 to 484. In other words, the same principles would apply in this case as would apply in any case where a foreign court had rendered a judgment.
But that's a little bit of a different question, right? That's the question about the preclusive effect and whether any preclusive doctrines would themselves bar the plaintiffs from seeking relief here?
Well, I think that, yes, it ultimately comes down to a question of preclusion, but if we believe the plaintiffs should first bring these claims in Hungary, if they did, and if they exhausted all available Hungarian remedies and they came back here and it turned out that they were denied relief on grounds that were somehow illegitimate for reasons of, if the Hungarian remedies turned out to be a sham or a fraud, then I think they could try to reopen these claims in the United States courts.
But why would that be? Because it seems that all of the concerns you're identifying, like the foreign cubed nature of this suit, would still apply even if they had exhausted their claims in Hungary first.
Well, I think it's appropriate for a U.S. court to ask in this context, as it does in other abstention contexts, whether there are available remedies in the alternative forum. And I think that plaintiffs should first seek relief from Hungarian courts, so you could call that an exhaustion principle. But once they do, if it turns out that Hungarian courts were not actually available, they could then press their claims in the United States. I think that should be a high bar, and it is a high bar under the restatement, but I don't think it's impossible in this case any more than any case involving a foreign judgment.
Thank you, Mr. Silbert.
A minute to wrap up, Mr. Silbert.
Thank you, Mr. Chief Justice. I'd like to emphasize two reasons why I think you should be skeptical of the arguments made by my friend on the other side. First, my friend's position creates the anomalous result that it's easier to sue foreign sovereigns for conduct in their own territory than it is to sue private defendants for foreign conduct. And that should be a big red flag. If a case against private defendants causes too much international friction, That problem only gets worse when foreign sovereigns are named as defendants. Second, my friend never owns up to the reciprocity implications of her position. The treatment of foreign sovereigns by U.S. courts suggests that the United States can be treated the same way by foreign courts. So if my friend is right that this case must proceed against Hungary, then analogous suits against the United States must also proceed in foreign nations' courts. That is not what Congress intended.
Thank you, counsel. Mr. Snyder?
Mr. Chief Justice, and may it please the court. For well over a century, this court has recognized that when an American court encounters a case that raises serious foreign relations concerns, the court may abstain from the exercise of jurisdiction as a matter of international comity if it determines that the case would be better heard in a foreign forum. Nothing in the Foreign Sovereign Immunities Act forecloses courts from applying that case-by-case abstention any more than it forecloses courts from applying the similar case-by-case analysis called for by the Forum Non-Conveniens doctrine. On the contrary, as Judge Katsas correctly explained below, Section 1606 of the FSIA requires that when foreign sovereigns can be sued in American courts at all, they must be treated no worse than private foreign defendants facing equivalent claims. Because private foreign defendants are free to seek comity-based abstention, Section 1606 therefore requires that foreign sovereign defendants must be free to do so as well.
Mr. Snyder, this question will not surprise you. You emphasize the significance of the international relations context as a reason for international comity, but your client, the United States, has scrupulously avoided taking a position on what the court should do, given the international relations context. This is the perfect time for you to fill that void. Why hasn't the government told the courts what the foreign relations impact on the United States is?
Well, Your Honor, the United States doesn't feel that it has sufficient information about how the proceedings would unfold in Hungary to take up.
How long has the case been going on that you haven't gotten that information yet?
Your Honor, the case has been going on for quite some time. I forget when exactly the complaint was filed in the case. We have the same information that the court has in terms of the party presentation and the expert declarations submitted in the case.
Well, I'm sure that's true, but you also have other resources like our embassies, other communications between the two countries at the executive level.
That's true, Your Honor. The State Department simply doesn't feel that it has sufficient information to provide the court with a recommendation.
Mr. Snyder, surely they have as much information as they need to make a decision. They just don't want to make a decision.
Your Honor, they have informed us that they don't have sufficient information to make a decision about that. Our interest in this case, though, is that more broadly, we think that the implications of the Court of Appeals decision would be detrimental to U.S. policy in as much as the Court of Appeals said that courts may never abstain on international comity grounds.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Snyder, doesn't it seem that your suggestion and petitioner's suggestion takes us right back to the case-by-case approach that FSIA was supposed to remedy?
Well, no, Your Honor. Let me answer that in a couple of ways. The first is that if you look to the text of the FSIA, I think it's very clear from the text that what the FSIA was directed to address was sovereign immunity specifically. And the doctrine that we're talking about here is neither an immunity nor is it only for sovereigns. And this court has repeatedly recognized that in adopting the FSIA, Congress was not intending to displace every other doctrine. So most closely analogous here, the court in Samantar recognized that the FSIA doesn't displace the very similar doctrine of official immunity. That remained subject to the common law rules. And we think the same thing is true here. Congress did not, in the text of the FSIA, seek to displace the international comity-based abstention, and so that doctrine remains available.
Does that abstention predate FSIA?
Yes, it does, Your Honor. If you look back at the Belgian Lind, as my friend said, the court in the Belgian Lind specifically noted that American courts have looked to the views of foreign consuls in deciding whether to to extend jurisdiction or to exercise jurisdiction over cases between foreign parties, and that in doing so, it took account both of questions of convenience and also questions of international comity. So we think that those are distinct strands.
Thank you.
Justice Breyer?
Well, it's the same question. One of the things Congress seemed to be upset about and wanted to pass the FSIA was contradictory information from state. The American strawberry industry wants to sue the country of Xanadu, run by a terrible dictator. But in Xanadu, our strawberry industry is being sued by some Xanadu nationals. And state wants to help our industry. Now all I have to do is reverse the situation, and they'll want to help them in opposite ways. So depending on who's being sued where, you get a different result when you ask state. Is it immediately in our interests or not, and how is American industry being hurt or helped? Is that something we should take into account in comity?
Your Honor, I think certainly courts can take account of American and foreign interests in applying the comity-based abstention doctrine. I think one important difference between comity-based abstention and sovereign immunity that helps to address some of the concerns is that, in our view, comity-based abstention looks in particular to whether there is an adequate forum in the other country, and that's not something that sovereign immunity would look to. So to the extent that Congress was concerned with ensuring that plaintiffs, especially American plaintiffs, would have a forum in which they could seek redress and that they would not be denied that forum based on political considerations, comity accounts for that in a way that sovereign immunity did not.
Justice Alito?
If this doctrine is all about the effect on foreign relations, if I were a district judge and I received a motion asking me to abstain on comity grounds, my first question would be, what does the government of the United States think about the foreign relations impact of this lawsuit? So won't you be in the position of having to answer that question every time this doctrine is asserted?
We don't think so, Your Honor. We think that there are certainly circumstances in which courts can make decisions about whether to abstain without needing participation from the United States government. There are certain considerations that are cross-cutting and that will always apply. So, for example, the United States certainly has more of an interest in adjudicating claims brought by United States citizens. The United States has more of an interest in adjudicating claims that concern conduct that occurred here in the United States.
I mean, what if the State Department says, we don't think that this raises foreign affairs concerns? Would that be dispositive?
I think that that should get substantial deference and might well be dispositive, Your Honor, yes.
I mean, there are almost 700 district judges. You want every one of them to assess whether a particular lawsuit raises foreign relations concerns?
Your Honor, we think that it makes sense for the courts to be able to do that. When this court has expressed concern about the capabilities of federal courts in addressing foreign relations issues, the concern has been primarily about courts creating tension unintentionally. This is a very different context. The question here is whether courts may abstain from the exercise of jurisdiction, and they will rarely create unintentional international friction by doing that. So the question is just whether you should completely foreclose them from doing so, and we don't think that you should.
Thank you.
Justice Sotomayor?
Counsel, I understood that the FSIA was passed to remove the pressure on the Department of State to decide whether or not it would grant immunity should be granted or not. I, like my predecessor colleagues' questions indicate, don't know how that pressure would stop in this situation. But I also don't know why that judgment has not already been made by Congress, meaning if we accept the argument in Germany that expropriations have to be as an international norm involve only expropriations of non-nationals and not domestic people, and we dismissed that case. Or if we ruled the other way and we say Congress intended for those suits to be in the United States, that yes, takings from nationals could have a forum here. I'm not sure how we can substitute, the court could substitute its judgment for Congress.
Well, Your Honor, we don't think that the court would be substituting its judgment for Congress. Whenever the court applies an abstention doctrine, it is by definition determining that in a circumstance where Congress in the statute allowed for jurisdiction, that the court is not going to exercise that jurisdiction. So we don't think that that a court should exercise jurisdiction, or abstain from jurisdiction under the international comity doctrine on grounds that would precisely replicate a judgment that Congress has already made.
All right. So why wouldn't the other doctrines that already exist, like forum nonconvenience, take care of virtually any other consideration would be addressed? Meaning the issue of foreign relations tension is exactly what the SIA was intended to, the judgment of Congress, that in these designated circumstances, those tensions should not lead to immunity. But why should they lead to abstention?
Your Honor, I think the FSIA had a more specific purpose, and you can see that from its text. It was about the circumstances in which courts should apply categorical immunity. But the court has recognized that that didn't deal with every other comity-based doctrine that preexisted the FSIA.
Thank you, counsel. Justice Kagan?
Mr. Snyder, you told the Chief Justice that the State Department didn't have enough information to make a decision in this case. But if the State Department doesn't have that information, how are courts to have it?
Well, Your Honor, we think that there's something of a difference between the scope of the decision that a court makes and the scope of the decision that the State Department makes. When a court makes a decision about whether to abstain in a particular case, the court is doing just that. It's making the decision about that particular case based on the evidence presented by the parties in that particular case.
I mean, I would think that that's exactly what the State Department would be doing here, too. They'd be looking at this particular case, the claims in this case, the alternative forum that Hungary is providing in this case, and they would make a decision. I mean, some might say that what's going on here is that the State Department is expecting the courts to do the difficult and sensitive and some might say dirty work for you.
I don't think that's right, Your Honor. The issue that the State Department has in particularly indicated that it doesn't feel it has enough information to provide a recommendation on is how this case would proceed in Hungary, and that's a decision that courts already make in the context of the foreign nonconvenience doctrine. And courts are well suited to address the adequacy of an alternative forum. We know that because, again, they do that already in the forum non-context.
Thanks. When I asked Mr. Silbert about the historical basis of this doctrine, he gave me the Belgian land case as his principal case, showing that this comity-based doctrine that you're espousing, in fact, has such a basis. In your brief, you call Belgian land an early example of forum nonconvenience. So what's your best case, best historical case for this comity doctrine?
Your Honor, I would say the same thing. The Belgian land is the best case on this. It is true that this court has described the Belgian land as a precursor of modern forum nonconvenience doctrine. But if you look at the Belgian land, it's describing a whole swath of cases that involve different considerations. So relevant to modern forum nonconvenience doctrine, it talks about declining to exercise jurisdiction on the basis of convenience. But it also says that courts do so for international comity grounds.
Thank you, Mr. Snyder.
Justice Gorsuch?
Mr. Snyder, I guess I'm curious about this. Is what you're arguing for a broad-based comity abstention doctrine or an exhaustion doctrine? In response to Justice Kagan, I believe you said that the real confusion for the State Department apparently lies in what remedies would be available in Hungary. That sounds like exhaustion. And Mr. Silbert, in response to Justice Barrett, indicated that after exhausting Hungarian remedies, plaintiffs would be free to come to the United States subject only to preclusion principles, which have nothing to do with abstention and would apply in domestically normal law. So what do you say to that? Is what you're arguing for really just an exhaustion argument?
No, we don't think it's an exhaustion argument. I mean, we think there are some similarities between the two, but in our view, it's appropriate for a court at the front end to make a decision about whether it would be appropriate to abstain based in part on whether there is an adequate form available in the other country.
Boy, that sure sounds like exhaustion doctrine to me.
Well,
that's exactly what courts do at the front end. They say, have you exhausted your remedies elsewhere before we take up your case? That is exhaustion.
Your Honor, to be clear, I'm not saying that the question is whether they have already exhausted them. I'm saying that the question is whether the remedies that would be available elsewhere are adequate. And so
we do that all the time under the rubric of exhaustion counsel. Okay, fine. Let's say they have to exhaust. Why? If Jewish victims of the Holocaust were deemed non-citizens, stripped of their citizenship, at least in Germany, why should they then have to go exhaust remedies elsewhere?
Well, we haven't taken a position on that, Your Honor, but let me point you to a case in which we have. There's an amicus brief filed in this case by SNCF, the French National Railroad, and that amicus brief describes a case in the Seventh Circuit in which the district court appropriately dismissed claims that had been brought against SNCF. We think that was appropriate on international comity grounds, because the United States has worked with France to establish an administrative mechanism by which claimants who lost property during World War II in France can seek redress for those injuries.
Thank you, counsel.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Snyder. Is it your position that when a foreign defendant has injured foreign parties in a foreign country, that abstention is necessarily appropriate?
No, Your Honor, we have not taken that right-line approach.
What else in that circumstance should a court ask itself?
Well, first I'd say that the court should look in that circumstance to the adequacy of the alternative forum.
Okay, if the alternative forum is adequate, anything else?
I think in that circumstance there would be a very strong case for abstention.
What could defeat that?
If the United States had some strong interest in the subject matter.
And how would a district court determine that?
So, for example, if the property that were at issue were in the United States, that might give the United States a stronger interest. If there were some question of the ongoing negotiation of a treaty, or if there were some law that Congress had passed expressing a particular interest in that subject matter, that might well affect the decision.
And was a district court to do all that on its own, or to seek the guidance of the State Department in that circumstance?
Well, I think, Your Honor, certainly the court should not foreclose the possibility of the district court doing so when the State Department provides input, but we think that there may also be circumstances in which a district court can do that without the State Department's input. There may be circumstances in which there's a statute that expresses a particular United States interest in the subject matter, things along those lines on which the district court could base its decision.
Thank you.
Justice Barrett?
Counsel, the doctrine that you're proposing of comity sounds like a little bit of this and a little bit of that. It incorporates some concepts from exhaustion and also sounds like forum nonconvenience. It also sounds like it incorporates some of the same considerations of foreign relations and friction with other countries that are addressed by the Foreign Sovereign Immunities Act itself. So would it subsume the need for some of these other doctrines? Like, what role would forum nonconvenience still play if we do adopt this broader comity doctrine you propose?
So I wouldn't call it a broader comity doctrine. I would say that it's a distinct comity doctrine. Forum nonconvenience is focused specifically on the litigants and their convenience and the convenience to witnesses, things along those lines. In an ordinary case, that makes sense. But in a case that presents significant foreign relations concerns, we don't think it makes sense to give weight to the plaintiff's choice of forum or the convenience of witnesses. Instead, it makes sense to look to those foreign relations.
Can I interrupt just for one moment? In this case, the foreign country or one of its arms is one of the litigants. So aren't its concerns taken into account in forum nonconvenience doctrine?
No, Your Honor. The considerations that forum non looks to are considerations of convenience. The interest that international comity-based abstention looks to is more of the sovereign dignitary interest in being able to adjudicate claims that are touch closely on that foreign sovereign's territory or its act in its own fora. That's something that this court spoke to in the Pimentel case, for example. We think those are just categorically different.
Thank you, counsel.
A minute to wrap up, Mr. Snyder.
The policy of the United States government with respect to claims for restitution or compensation by Holocaust survivors and other victims of the Nazi era has consistently been motivated by the twin considerations of justice and urgency. To that end, the United States has advocated that concerned parties, foreign governments, and non-governmental organizations act to resolve matters of Holocaust-era restitution and compensation justly through dialogue, negotiation, and cooperation wherever possible. The potential availability of comity-based abstention in United States courts plays an important role in our diplomatic efforts on that issue. Accordingly, while the United States takes no position on the appropriateness of comity-based abstention in this particular case, the court should make clear that the FSIA does not foreclose such abstention.
Thank you, counsel. Ms. Harrington.
Thank you, Mr. Chief Justice, and may it please the court. I want to start by addressing the United States' interest in having these types of claims adjudicated in U.S. courts. This country has a strong and long-standing interest in directly helping Holocaust victims seek justice. Today is Pearl Harbor Day, and it marks 79 years exactly since the U.S. was drawn into World War II. The reason the atrocities at places like Auschwitz were stopped and were exposed to the world is due in large part to our soldiers who sacrificed in the name of the United States. This court has held over and over that our Constitution assigns responsibility for foreign policy to the elected branches, not to courts. And over the last 70 years, those branches have repeatedly taken steps to make it easier for plaintiffs to pursue Holocaust-era claims like these in U.S. courts. For example, more than 2 decades before the FSIA was enacted, the executive branch waived application of the Act of State doctrine in Holocaust-era expropriation cases, explaining in the so-called Bernstein letter that it sought to remove obstacles to courts' jurisdiction to decide such claims on the merits. When Congress enacted the FSIA, it made clear that U.S. courts have jurisdiction to decide these types of claims. And Congress has updated the FSIA and enacted other legislation to make it easier for plaintiffs to pursue Holocaust-era claims in U.S. courts. Hungary and the U.S. now ask this court to recognize an abstention doctrine that would permit courts to overrule Congress's foreign policy determinations with no involvement from the executive. Such a doctrine runs afoul of separation of powers principles and has no foundation in our legal history. It would also undo the primary purpose of the FSIA, which was to eliminate ad hoc determinations about when courts should exercise jurisdiction over foreign sovereigns based on the foreign policy concerns of the moment. Hungary wants courts to decide whether these are the types of claims that should be heard in U.S. courts, but Congress has already decided that they are.
Counsel, we said in the Verlinden case that the FSIA does not appear to have affected the doctrine of forum known convenience. Now, if that's true, why has it affected the doctrine of international comity?
Well, Mr. Chief
It does seem that the theory of your argument would sweep very broadly and call into question not only foreign known convenience, but the act of state doctrine and other related theories.
Sorry for the interruption. Mr. Chief Justice, I have 2 answers to that. First is that we don't think there was an independent doctrine of comity-based abstention before the FSIA was enacted. The petitioners in the United States have not identified any case that wasn't either a foreign sovereign immunity case or a forum nonconvenience case. But second, to the extent that the FSIA displaced any existing common law doctrines, they were doctrines that were directed to foreign sovereign immunity or things like that. So my friend Mr. Silbert describes the comity inquiry as directed to the dignity interest of the foreign sovereign. To the extent that's different from a foreign sovereign immunity inquiry, it's hard to tell how it's different, but it would have been subsumed by the FSIA. In contrast, the forum nonconvenience is a generally applicable common law doctrine that survives, and generally when a statute is enacted, we don't think that it displaces generally applicable common law doctrines that aren't directly sort of addressed by the statute.
Counsel, your position is categorical. In other words, you don't think their international comity applies in any case. And yet it's, given the nature of international relations, it's easy to envision cases where it would seem particularly inappropriate for United States courts to get involved in litigation. I don't know if this is one of them or not. I mean, is there room for any kind of a safety valve under your theory where the doctrine is, while maybe not available in the normal course, is appropriate in particularly sensitive international relations cases?
Mr. Chief Justice, I think there are a number of safety valves that already exist, including things like statute of limitations, the active state doctrine, political question doctrine, forum nonconvenience. In addition, we also have our fallback argument that if you disagree that there is no doctrine of comity-based abstention that's available, it should at least only be available where the executive branch comes in and asks for a specific case to be dismissed. That would respect the constitutional assignment of foreign policy authority to the elected branches and would maintain political accountability for those kinds of decisions.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, if we reverse in the, again, this is a hypothetical, if we were to reverse in the Germany case, what should we do with this case?
I think you should affirm in this case. So first I'll say I think you should not reverse in the Germany case. I think there's a strong textual argument that takings that are themselves acts of genocide are covered by the expropriation exception. I also want to say there are reasons maybe to view the facts alleged in the Germany case differently from the facts alleged in this case. In this case, the plaintiffs allege that Hungary took every single thing they owned, including things that are necessary for survival, and that is more clearly a genocidal type of taking, perhaps, than the takings that are alleged in Germany. But there are also these alternative arguments that are available and that were raised by us below, which is that the plaintiffs, some of our plaintiffs were never Hungarian nationals. They lived in occupied territories and were never treated as Hungarians. And so they should have an opportunity to make their claim under whatever rule this court says applies under the expropriation exception. The other plaintiffs were certainly not treated as Hungarian nationals or citizens. They were stripped of all rights and privileges of nationality, and they should similarly have a chance to make their claim.
Could you spend a little bit of your time to explain whether or not you preserve the genocidal taking argument?
We did that. That issue was decided in this case in the first appeal in the D.C. Circuit. Hungary did not raise it in its cert petition in this case, but of course, as you know, Germany did, and you granted cert on that question. It's a question that goes to subject matter jurisdiction, and perhaps you're asking why we chose to address it, even though it's not one of the questions presented in this case raised by Hungary. And that's because, as I said, we think that considering that question in the context of the facts of this case is clarifying, and also it is a subject matter jurisdiction question that Hungary has said it intends to take advantage of if Germany prevails.
In your answers, you seem pretty firm that under FSIA, there's no room to create new abstention doctrines. What's your view of a court staying FSIA proceedings?
Well, it would depend on the basis for staying. As one of your colleagues has said, there is generally an unflagging obligation to exercise jurisdiction that's been given by Congress. There are some abstention doctrines that will allow a court to stay damages actions when there are, for example, pending proceedings in another forum. There's no such pending proceedings in this case.
Thank you.
Justice Breyer?
Thank you. A group of victims of apartheid sue, maybe they're from Botswana, they sue the South African government on a claim that fits within this for taking their property, etc. South Africa says, you don't understand. We don't have apartheid anymore, and we have a system for dealing with it. It's called the Truth and Reconciliation Committee. Please don't mess up what we're trying to do, Judge in New York. Dismiss the case or use comity. What's supposed to happen on your theory?
Well, I think we could imagine in that case perhaps the State Department would come in and say to the...
Okay, I see what you're doing. You're taking some factors and saying it doesn't zero exist. It exists, but only a few things are allowed to appeal to comity. Is that right?
Justice Breyer, we think it doesn't exist, but we think if the court disagrees with that, it should at least...
Yeah, I got that point. But my question is, fine, you think it don't exist. It doesn't exist. So when the people from Botswana sue on apartheid the South African government, and the South African government says, please don't do this, you're going to mess up our truth and reconciliation, the answer for your first choice is to say, too bad. We go ahead with the suit anyway. Is that right?
It's right if all of the requirements of the FSIA are met.
Now take your second position. Your second position says, well, maybe not sometimes. And that's where deference to well-considered views of the executive branch. That's one of them. You agree with that one, right?
Yes.
Then you agree with the general practice of other nations, particularly the reciprocal practice of a nation directly implicated.
Justice Breyer, we think that's a question for Congress or perhaps the executive.
So you say don't take that. Even if every other nation does it the different way, don't do it. I'm just trying to get your position on this.
Yes, because
well, what about the third? Applicable of U.S. statutes or treaties that demonstrate a strong sovereign interest to ignore or displace foreign sovereign acts or interests in this situation.
If claims have been displaced by Congress or the executive, then the claims have been displaced. I just want to make one point on the reciprocity point, which is that the expropriation exception does not exist anywhere else in the world in the context of foreign sovereign immunity. And so that sort of reciprocity risk is baked into the statute intentionally by Congress.
Okay. Then what I'm doing, I'm reading to you, as you know, Professor Eistracker's 4 considerations that would go into comity. And so it seems to me that or at least your second choice, is you agree with some but not others.
Right. I mean, our basic
principle... Is that right?
That's right, yes. Our basic principle is that those professors are asking district courts to make foreign policy determinations. That's not the constitutional role of a district court. I mean, under separation of powers principles, those determinations are assigned to our elected branches. Here, Congress has made the comity-based decision about what types of claims can be brought in U.S. courts. In Verlinden,
you would read that statute as saying, well, South Africa, you're trying to end the bitterness caused by apartheid, but that's just too bad.
I mean, if all of the requirements of the FSIA are satisfied, then yes.
Yes, okay.
But again, the executive branch can come in and try to intervene. They have not done so in this case. They've been invited multiple times to express their view about whether this suit should be dismissed, and including today, and they have declined to do that. It shouldn't be up to a district court to make that foreign policy determination in the absence of direction from the executive when Congress has provided jurisdiction.
Thank you.
Justice Alito. Counsel, I think you really do have to choose between two alternatives. Your primary argument is never. This doctrine doesn't exist. There are no circumstances in which a case could be dismissed based on comity abstention. And so if there were a case at some time in the future where going forward would cause grave foreign policy problems, your answer has to be that's just too bad. Is that your argument?
So I'd say two things. First, as I mentioned to the Chief Justice, there are a number of other doctrines that will weed out lots of these cases, like forum nonconvenience, political question, active state, things like that. But second,
but there could be cases that don't fall within any of those doctrines that could have very serious foreign policy implications. I mean, your argument might be right, but you have to say yes, even if it means war, even if it means very serious foreign policy problems, we want you to say never. Or you have your fallback argument, which is, well, maybe if the State Department comes in and says, please do not go forward with this, it will cause terrible international repercussions. That's a fallback argument, but that argument negates your primary argument that this doctrine never existed and therefore it doesn't exist at this time.
Right. We think Congress has already made these foreign policy determinations and these taken into account comity when it enacted the FSIA. As we explained in our brief, Congress and the executive can step in and settle certain categories of claims that they think pose a sort of risk to foreign policy. They haven't done that here. And as a fallback, and it is an alternative argument because it would sort of undermine our argument about comprehensiveness and clarity of rules. But as a backup argument, we're saying, if you're going to dismiss a case based on foreign policy concerns, it really shouldn't be a court, with all due respect to courts, that's making that decision. It should be an elected branch of government.
Well, there is the do no harm principle, and the only issue that is before us, assuming that that you would prevail on the jurisdictional question, is whether this doctrine whether we should hold that this doctrine doesn't exist at all, can never be invoked under any imaginable circumstances. It could be that this is just a very, very narrow doctrine. All we would need to decide is it does exist in some form.
Justice Alito, I think it would be helpful to provide more guidance than that, precisely because the FSIA was meant to get rid of this system where you made these sort of case-by-case ad hoc determinations based on the foreign policy considerations of the moment. It was intended to get rid of what this court has called the bedlam of these sort of inconsistent rules and sort of, as I mentioned, the ad hoc determination of whether and when courts should exercise jurisdiction. And so if you're going to say sometimes you can have comity-based abstention, it would be helpful to have some guidance about when that is. And I think the factors that Hungary and the United States have pointed to, that's just a subset of factors that are already accounted for in the forum nonconvenience doctrine, and those are the factors that are already accounted for in the FSIA and generally in the Foreign Sovereign Immunity Doctrine.
But, Congress could, if Congress wants the answer to be never, Congress could so provide, as it has in some statutes. Why should we take the lead on that?
Well, I think the existence of the Foreign Sovereign Immunities Act, which is a finely reticulated and frequently updated statute, is a strong indication that those are the rules that are intended to apply when you're asking about when a court should exercise jurisdiction over a foreign sovereign.
Thank you, counsel.
Justice Sotomayor?
Counsel, I'd like to follow up a little bit on Justice Alito's question, but my simple question to you is, again, hypothetically, if we were to rule that there is no international expropriation, customary international law for expropriation from national, do you also believe that we should address this comity issue, notwithstanding that we held there was no jurisdiction?
I think you would need to, because even if you think that there's no jurisdiction under the theory that these takings are genocidal and therefore violate international law, as I mentioned earlier, the plaintiffs still should have a right to make a case that they would fall in under whatever rule you announce does apply. So as I mentioned, some of the plaintiffs were never Hungarian nationals. They lived in occupied territories. The rest of the plaintiffs were certainly stripped of all of their rights and privileges of nationality and citizenship before they were kicked out of their homes and forced into ghettos and then deported to be murdered in the death camps.
All right. Then one follow-up question to this. Assume that we find a never answer to be inappropriate, because we have at least two shipping cases, the Carolina and the Infanta, in which 19th century courts declined jurisdiction, at least in part out of concern for commercial relations between the U.S. and a foreign sovereign. So it does suggest some equity principles or comity principles that have guided courts in the common law. So if we never say never, how should we write it?
Well, Justice Sotomayor,
to narrow it, what sort of extremes do you think might justify the use of that doctrine?
So sorry for the interruption. I would first say I think those cases that you cite are really viewed as forum nonconvenience cases. Mr. Silbert says that forum nonconvenience, and Mr. Snyder said too, is just directed to the convenience of the parties. But there are also the public factors that have to be taken into consideration, and those address the interests of the two different court systems in hearing the case. And so I think those cases are examples of forum nonconvenience cases, not comity cases. But if you're going to actually answer your question, I think what you would need is some indication from one of the elected branches that there is actually a foreign policy concern. I don't think you can have a court abstaining from exercising its jurisdiction based on its own assessment of a foreign policy concern.
Thank you, counsel.
Thank you.
Justice Kagan.
Ms. Harrington, on much the same subject, I mean, just think about these cases particularly. I think it's not yours, but the Hungary case in the Seventh Circuit, which involved very similar claims, it had potential damages amounting to 40% of Hungary's GDP. So this is a suit that could essentially bankrupt a foreign nation. Now, that seems as though it's screaming severe international friction. Why shouldn't we be able to acknowledge something like that?
Well, Justice Kagan, I think any sort of speculation about the damages amount that would be implicated in this case is just that it's pure speculation at this point. No class has been certified. We don't know how large the class would be if it were certified. And so I don't think a district court at the very front end of a case should be saying, well, maybe if it was a giant class and they proved all their damages, it would be too much money, and therefore we should just abstain from exercising jurisdiction. That's just not normally the way that kind of inquiry works. And again, if the United States thinks it's a problem, they can come in and say so, as they have. I mean, Hungary is very different from many of the other Axis-allied and Axis-abetting countries in that it has never taken any steps to reach a comprehensive settlement. If you have countries like Germany, Switzerland, France, Austria, who have cooperated with the United States to create these alternative fora to resolve these claims on a global basis.
That was going to be my next question, Ms. Harrington, because the SG tells us that if we don't recognize this kind of abstention, then the government is going to be hampered in its efforts to encourage the establishment of redress and compensation mechanisms for human rights violations. And in some countries, that has worked to at least some extent. So what's your answer to the Solicitor General's position on that score? And do you really think that we can treat Hungary differently because those efforts have not succeeded as well?
So this court explained in the Garamendi case that it was actually the filing of class action lawsuits related to Holocaust-era claims that spurred those other countries to create these alternative fora in cooperation with the United States. And so I think it's absolutely backwards to say, well, we should just get rid of all these suits, and that's going to actually be the thing that motivates the remaining countries to come to the table. And in terms of whether we should treat them differently, the United States treats them differently. I mean, the United States came into this case and the district court uninvited and asked the district court to dismiss the Austrian-owned company that was the other defendant precisely because Austrian companies have come to the table and created this alternative way to resolve these disputes on a global basis. They didn't do the same for Hungary or the Hungary-owned railroad. And so the United States is obviously treating them differently in that respect, and it's perfectly appropriate for the court to do so as well.
Will your position leave private litigants in a better position than sovereign litigants?
It won't. I mean, I don't think Hungary relies on these couple of courts of appeals that in the last 15 years have recognized a doctrine of international comity-based abstention. Those cases came 30 years after the FSIA was enacted. And in the two primary cases that they rely on, the United States actually did come in and specifically request that the cases be dismissed. That's Ungaro, Benages, and Mujica in the Ninth Circuit. The first is in the 11th Circuit. And the courts in those cases gave dispositive weight to the United States' request that the suits be dismissed based on foreign policy concerns. So it's just not true that it's easier to sue foreign sovereigns than private plaintiffs. In fact, the only Holocaust-era class actions, or most of them that have actually reached a substantive result in U.S. courts, have been against private companies.
Thank you, Ms. Harrington.
Justice Gorsuch?
Good morning, Ms. Harrington. I'd like to address a slightly different point that you've alluded to a couple of times. Normally, takings within a country are subject to domestic takings laws. You've argued in this suit that the Holocaust and human rights forms an exception to that rule, but you've also pressed the point and alluded to it today that even if that rule were normally to apply, it wouldn't here because Germany and perhaps Hungary stripped citizenship from its Jewish victims during the Holocaust. It's a very interesting argument, but it's not developed much in this court, and I'm just curious why and what we should do about it.
It hasn't been developed much in this court because it's not actually the question that's presented. It's not the basis that the D.C. Circuit relied on in deciding the two cases. I think that is an issue that would need to be resolved on remand. I think that's the most appropriate way to resolve it since it hasn't really been briefed and wasn't squarely presented in Germany's cert petition.
Thank you.
Justice Kavanaugh?
Good morning, Ms. Harrington. I think you agree that foreign nonconvenience survives the FSIA. So I take from that the FSIA would not displace comity if a comity doctrine exists and existed at the time. And you've made important arguments, as have Professors Dodge and Gardner, that the doctrine doesn't exist. And I understand those, but put those aside for now. If the doctrine does exist, then the question is how to apply it. And I did not view it necessarily, again, assuming it exists, as requiring a case-by-case foreign policy or international friction evaluation, in part for reasons others have expressed. That would not be predictable. It would be hard for courts to do that. Wouldn't necessarily be equitable, given the number of courts who would be involved, hearing similarly situated plaintiffs. Rather, I viewed the doctrine, at least as it's been articulating, as reflecting a general foreign policy concern, and then the question becomes the particulars of the doctrine. And I had understood the argument to be that if foreign defendants harm foreign parties in a foreign country and remedies are available in the foreign country, then an American court should usually abstain. So again, if the doctrine exists, what is the problem with that kind of fairly bright line principle that would not require a case-by-case evaluation of foreign policy interests?
Well, Justice Kavanaugh, any such doctrine was plainly displaced by the FSIA. This court held in Verlinden that Congress intended in the FSIA to grant U.S. courts jurisdiction over suits by foreign plaintiffs against a foreign sovereign based on domestic state law. And the expropriation exception that we're relying on here expressly applies to conduct that occurred abroad. It's principally directed to nationalization of property, and that has to occur abroad. We think it also applies here where you have genocidal takings, but there's no reason that those shouldn't also be covered if they happen abroad. And so, to the extent any such doctrine like that did exist, we think it was plainly displaced by the FSIA. And it was not, it was sort of not a consideration that was separate from foreign sovereign immunity determinations that were made at common law.
But if such a doctrine exists and the articulation I just provided applied to private foreign defendants as well, still have the same argument?
Well, I mean, it would depend on the context. Hungary relies on the ATS cases, but what the court is doing in the ATS cases is just fundamentally different from what it's being asked to do here. There, what the court is doing is asking whether there is jurisdiction, not making a determination about whether courts should abstain from exercising jurisdiction that plainly exists. And so the sort of separation of powers and small c conservative way that courts should sort of wade into foreign policy determinations points in the opposite direction in the two types of cases. Here, if a court says, I'm going to abstain from exercising jurisdiction, it's countermanding foreign policy determinations that Congress has already made. In the ATS context, if a court says, I'm going to recognize this inferred cause of action, it's kind of venturing out into a foreign policy way, in a way that Congress has not yet done.
But that would lead, if that applied the way you just described it, that would lead to a private defendant case, and the court would abstain, and a country defendant case, the court would not abstain, which seems unusual.
Well, it wouldn't be an abstention, Justice Kavanaugh. It would be a determination that there is no jurisdiction in the first place. And, that's a determination that's up to Congress to make.
Okay, I take that point. Thank you very much, Ms. Harrington.
Thank you.
Justice Barrett?
Good morning, Ms. Harrington. I have a question about the nature of this kind of comity doctrine, especially as compared to foreign nonconvenience. So everybody agrees that foreign nonconvenience doctrine survives the enactment of the FSIA. And I'm wondering why, in your view. Is that because foreign nonconvenience doctrine is a background principle that's incorporated somehow into the statute itself, or is that because courts retain the power to develop it as a common law doctrine? And if the latter, why wouldn't they retain the power to develop a doctrine of comity like Hungary proposes here?
So it's more the latter. I mean, there's a general background principle that statutes don't displace common law, sort of generally applicable common law doctrines, unless there's some indication in the statute itself that that's the intent of the statute. And so, for example, foreign sovereign immunity, everyone agrees, was a common law doctrine that was displaced by the FSIA. To the extent there was any separate comity abstention doctrine, which we don't think there was, but if you disagree, we think it was also subsumed within and displaced by the FSIA. Because as my friend Mr. Silbert described the comity-based inquiry, what the court is supposed to do is think about the dignity interest of the foreign sovereign. It's really hard to see how that is separate from the Foreign Sovereign Immunity Doctrine in a way that the FSIA was not intended to account for.
So your argument is that courts may retain some authority to recognize some of these abstention-based doctrines like foreign nonconvenience, but the structure and the text of the FSIA preclude us from doing so here?
Yes. I just add that the State Department, when it transmitted the draft bill in 1973 to Congress, it included a section-by-section analysis, and in that it said, we don't think this would displace foreign nonconvenience doctrine. So it was sort of baked into the enactment history of the FSIA.
And let me ask you a question about this citizenship point. You point out that some of the plaintiffs in the suit below were not Hungarian nationals, and others have a claim to their citizenship having been severed by the genocide. Is that a claim that you raised below? As Justice Gorsuch pointed out, it's not one that's developed here. It wasn't part of the QP. Did you raise that below or develop it all below? And if not, did you have to in order to preserve it?
We did raise it below, and I regret that I don't have the exact citation, but it was raised in the briefing on appeal.
Okay. Thanks, counsel.
You have several minutes to wrap up, Ms. Harrington.
Okay, thank you, Mr. Chief Justice. I just want to sort of linger for a second on the separation of powers point. The Constitution assigns authority over foreign policy to the elected branches. Here, Congress has decided that this type of claim, this is the type of claim that U.S. courts should hear. And the executive, even after being invited multiple times to disagree with respect to this specific case, has declined to do that. In these circumstances, a court should not be able to step in and disregard its statutory jurisdiction based on its own assessment of foreign policy concerns. That scheme would raise serious separation of powers concerns and would completely undermine the central purpose of the FSIA, which was to eliminate case-specific foreign policy concerns from questions about when a court should exercise jurisdiction over a foreign sovereign. And just one final point, I would like to just say another word on the other question that you're considering this morning in the Germany case. That question is whether a taking that is itself genocide is a taking that violates international law. Under the plain and broad text of the expropriation exception, it is. And considering that question, I really invite the court to consider the facts of this case, which arise out of the worst atrocities in human history. Here, Hungary took everything the plaintiffs owned, including possessions necessary to survive, such as shelter, clothing, and medicine. And the undisputed purpose of Hungary's takings was to bring about the physical destruction of Jews in Hungary. That is genocide, and it is hard to imagine a more vivid example of property takings that themselves violate international law. Indeed, the only U.S. interest that the Solicitor General's Office or the Department of Justice has identified in this case in the 10 years of litigating it is the moral imperative to provide victims of the Holocaust with some relief in their lifetimes. There's no way to read the text of the expropriation exception as withholding jurisdiction in this case, and there is no room in the FSIA's comprehensive scheme to allow abstention based on international comity. Thank you, Mr. Chief Justice.
Thank you, counsel. Rebuttal, Mr. Silbert.
Thank you, Mr. Chief Justice. I have 3 points. First, I did not hear my friend give you any real workable limiting principle or safety valve for her position, and I think that colloquies with Justice Breyer and Justice Alito brought that out. The fact is, if you accept my friend's interpretation of the FSIA, then U.S. courts not only can but must hear cases alleging that foreign sovereigns harmed other foreigners in foreign countries. There's no doubt that those cases will be asserted here, and some of them will be highly problematic, like the South Africa hypo that Justice Breyer proposed. I think foreign nations will be understandably upset if U.S. courts adjudicate foreign disputes where foreign interests predominate and there is little, if any, U.S. interest on the other side. When U.S. courts decide cases like that, they cause meaningful harm to international relations, and they expose the United States to similar litigation in foreign courts. Second point, I think the text of the FSIA just does not do the work that my friend needs it to do. The expropriation exception withdraws sovereign immunity from jurisdiction. It doesn't do anything else. The comity abstention doctrine that we're asserting predates the FSIA by about 100 years. So the question is whether the FSIA affirmatively displaced it, and clearly it did not. If the FSIA actually displaced all comity defenses in favor of a foreign sovereign, as my friend proposes, then the active state doctrine would also be displaced. But this court held in Altman that it isn't. If Congress wants to go further and invite the kinds of foreign policy consequences that will follow, if U.S. courts are compelled to hear cases like this one, then Congress can certainly do that. But that is not what Congress said in the FSIA, and the courts should not take on those foreign policy risks on their own without clear instructions from Congress and the executive. Last point. I think you should take the reciprocity concerns in this case very seriously, because it's an unfortunate fact, but a fact we all know, that the United States government has sometimes fallen short of the ideals of justice that every nation should aspire to meet. And some people say that the United States owes large outstanding debts for injustices that were committed in this country. That's a profoundly important question. Maybe one day Congress will address it, or maybe one day it will come before this court. But I bet we can all agree that the remedies for the worst injustices committed by the United States in the United States should not be decided by a Hungarian judge applying Hungarian law from a courtroom in Budapest. For the same reasons, the merits of this case should not be decided by an American judge applying American law in Washington, D.C.
Thank you, counsel. The case is submitted. We will hear argument next in case 19-351, the Federal Republic of Germany versus Philipp. Mr. Freiman?
Thank you, Mr. Chief Justice, and may it please the Court. When Congress enacted the expropriation exception in 1976, communist states had been engaging in widespread expropriation of property from American nationals and denying that the international law of takings required them to pay compensation. Congress enacted a series of targeted measures, including the expropriation exception, to counter these states' rejections of the law of takings. The exception lets U.S. courts hear claims against foreign sovereigns when rights in property taken in violation of international law are an issue. That language invoked the established international law doctrine known as the law of takings. As the restatement and other sources show, the doctrine addresses only nations' takings of foreigners' property. And by referring to it, Congress incorporated its limits into the expropriation exception. The plaintiffs ignore this context, trying to turn this modest exception into a novel tool for suing foreign sovereigns for human rights and law of war violations occurring in their own countries. That reading should be rejected for three reasons. First, it ignores the established meaning of the exception's words when enacted in 1976. Second, it creates a jurisdictional mismatch with the exception's text. The exception focuses on rights in property, giving jurisdiction over property claims. It would be bizarre for courts to decide if a state has violated human rights law by murdering its own nationals just as a jurisdictional hook to hear a property claim. And finally, every applicable canon points away from a reading that would depart sharply from the restrictive theory, put the U.S. deeply in breach of the international law of state immunity, blur the jurisdictional lines over foreign sovereigns where clarity is needed most, cause friction in foreign relations, and risk reciprocal treatment against the U.S. Congress can take these risks if it wants to, but it hasn't yet.
Counsel, just to make sure, your position is because this suit involves property rights, it should not be regarded as a qualification of the international law or a case in which genocide is a pertinent issue in deciding the question of jurisdiction.
That's right, Your Honor. We believe that A3 explicitly is invoking and referring to the international law of takings that the legislators would have known in 1976 when enacting the statute against that backdrop.
Well, why do you think that expropriation of property can't be part of a campaign of genocide?
Well, property can be expropriated in a number of contexts, but the gravamen of A3 is the taking of property, and the law that it's referring to is the international law of taking. I think a genocidal taking, as Your Honor puts it, is unquestionably an act of genocide if it inflicts conditions of life calculated to physically destroy a people, but it's not a taking of property within the meaning of the expropriation exception.
Well, I guess my question is why that is. If it is part of a campaign of genocide, that doesn't alter the fact that it's simply taking property?
Well, I think there's three reasons, Your Honor. In terms of the evidence that Congress was intending to invoke the international law of takings in A3, the text, of course, is referring to language in international law. So the question is what takings are wrongful under international law. And the restatement provision operable at the time answers that question with the section asking when are takings wrongful under international law. I think second is the statutory context. You had the Sabatino decision of this court followed by a series of targeted responses of increasing force to foreign nations that refuse to recognize the existence of the international law of takings.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, I understand your argument about with respect to taking, but can't just imagine that there's a campaign, first of all, of genocide, but in conjunction with, and a part of that, there's an effort to take all of the property, including jewelry, art, and even the extraction of gold teeth, for example. Taking of things like spectacles. You can go down the list of some of the awful things that were done. Can that be a part of genocide? Can that taking be a part of genocide, not separate from genocide?
Well, Your Honor, if in fact a country is taking property with the intent of physically destroying a people or a part of a people, it's unquestionably a genocidal act. But the question, again, is what Congress intended in A3. Was it invoking any kind of anything that could be described as a taking, or does it have to be the gravamen of the claim? I mean, here, the gravamen of the claim in the example you gave would be genocide, but Congress did not see fit to create any kind of exception for genocide claims or other international human rights or law of war claims.
But don't you think that 1605H and the way that it sort of allows for the systematic campaigns of coercive confiscation of cultural art, doesn't that suggest that when it's aimed at a vulnerable group that it is actionable under FSIA?
I think the important thing to recognize about the Clarification Act is that it did not amend A3. It took it as a given. And the key here is what A3 says and what the words meant then. H clarified the commercial nexus requirement and saying that in general, an art loan from another country isn't commercial activity in the U.S., but it created a carve-out for Nazi-era claims. That carve-out just left the pre-existing commercial nexus definition. But it also, H expressly leaves the definition of property taken in violation of international law untouched. To change.
Thank you, counsel. Justice Breyer?
Well, am I right in thinking that a plaintiff, Mr. Smith, wants to sue a foreign country because he was injured during a genocide, deliberately, seriously injured? Now, he might be able to bring a suit against a private person who participated, perhaps, but he cannot sue the government. Is that right?
That's correct.
Okay. So now we're looking for whether he could sue the government, although otherwise he couldn't. If the government, instead of hurting him, maybe they did hurt him too, but he might be able to sue for some of his things of value. Is that correct?
That's the plaintiff's theory, Your Honor.
That's the plaintiff's theory. All right. So why is it, this is a slightly different question, and it's just to satisfy my own curiosity, really 75, 85 years later, this seems to be the first case that has arisen on this theory. Am I right? Is there precedent?
Your Honor, these cases began to arise a few years ago, the Fisher and Abelish cases in the Seventh Circuit, and then the two cases you're hearing today. Until then, as Your Honor noted in the Altman case, the consensus view was that these cases could not be brought.
Well, how did Mrs. Altman recover?
Well, Mrs. Altman, in fact, was a Czechoslovakian national, and her property was taken.
Still, she's a Czechoslovakian. Oh, I see. Mrs. Altman was, but her aunt wasn't.
Well, the plaintiff in the case, the person from whom the property was taken, was a Czechoslovakian national. So that was not a.
So that was an expropriation in violation of the. Oh, okay, I see. Yeah. Thank you. Thank you.
And Your Honor, I would add that in the Malevich case, which is the case that gave rise to the Clarification Act, the same was true. That was a Dutch taking from a Russian national.
Justice Alito?
The ancestors of the plaintiffs in this case were all German nationals?
Yes, Your Honor.
What if they were stripped of their citizenship prior to the taking of the property?
Well, I'd say a few things in response to that. First of all, the entity from which the property was allegedly taken was a company, the consortium, which was itself owned by three firms underneath that, which were also companies. So this is a case of claimed takings from German national companies. But in response to your question as to the individuals here, this sale transaction was finalized in the summer of 1935, according to the amended complaint, which is before the Nuremberg laws went into existence, before Jewish Germans were stripped of German citizenship. So it wouldn't be relevant here. Finally, to the extent that they were stripped of citizenship, the question under the international law of takings is not the citizenship, but is the nationality of the individuals.
Well, that would get into some very difficult questions concerning the nationality of people who lived in parts of Eastern Europe that were that had been disputed among the countries in that region for some time. But getting back to the issue of timing, in the Clarification Act of 2016, Congress defined the covered period as beginning in 1933. So in Germany, were there takings in violation of international law under your interpretation prior to 1938? In other words, cases in which the property of non-German Jews was taken by the Third Reich?
There's nothing in the record with regard to that either way, Your Honor, but I have no doubt that that occurred.
Well, if it occurred, would it be more than a trivial number of cases? And if so, why would Congress have gone out of its way to define the covered period as beginning in 1933?
I can't speak as to the number of cases that it was. That's a historical question that, again, has not been litigated here. But I would say as to why Congress would define the covered period as beginning in 1933, Congress was doing something very simple. It was saying the entire Nazi era, from the time that the Nazis came to the power until the time that they were defeated by Allied forces.
Justice Sotomayor?
Counsel, what is your position about the arguments Hungary makes, the arguments presented in the Hungary case?
As you know, Justice Sotomayor, we raised as the second question presented the same comity issue that this court has just heard argument on in the Simon case, and we, in large part, agree with the comments made by counsel for Hungary and for the Solicitor General in that case.
You do not have, however, a remaining claim in which we would have to decide the comity issue if we decide against you on this main issue, hypothetically.
If you decided in our favor in this case, there would be
no. I'm sorry, I misspoke, yes.
If you decided in our favor on this issue, then there would be no reason for you to reach the comity question in our case.
Number two, we are generally instructed, self-guided, to rely on the plain meaning of the words that are presented in the statute. And the plain words in the statute here is in violation of international law. And it's clear to me that genocidal acts of taking property, even from nationals, would be an act of genocide. I think that's clear from the Clarification Act today. So why don't we follow the plain meaning of the statute, and why should we look to customary international law as opposed to simply the plain meaning of the words?
Well, I think, Your Honor, you have to look at the plain meaning of the words in their context and in their time. And as Bostock made clear recently, when there's a difference in the meaning at the time of enactment as opposed to the present day, and there's evidence of that, you do need to look to that. Here we have a situation where the House report specifically refers to a taking in violation of international law as a term, which means that it's referring to a body of law, and it cites the second Hickenlooper Amendment. It cites this court's decision in Alfred Dunhill, which was involving Cuban expropriations, came down just months before the FSIA.
Justice Kagan?
Yes, Mr. Freeman, we look to the meaning in its time, but I guess I don't quite understand what words in this statute meant something different in its time. Rights and property mean the same thing, and then you have, taken in violation of international law. I understood you to concede the point the property can be taken as part of, as an important element of genocide, so that property can be taken in violation of international law. So why doesn't that just solve the problem? It's a matter of reading the plain meaning of the text, what it meant then as well as what it means now.
I think the important thing is to read the clause as a whole, and the term here is taken in violation of international law, which, as noted, was something that had a defined meaning in the international law of takings, which is what Congress was addressing in responding to the communist expropriations.
I guess, Mr. Freeman, it's clear that Congress was thinking about a certain thing primarily, which is context, but the Congress wrote words which didn't deal only with that thing, but which applied more broadly, and seems to cover the kind of property taking at issue in this case.
I don't think so, Your Honor, because I think the question is, what's the gravamen? If there's a claim that there were conditions of life that were created that led to the potential destruction of a people, that's a claim of genocide. That's not a claim of a taking. And A3 is involved with taking claims. Now, if you look at the other parts
I understood you to say the opposite a little while ago, that you weren't contesting that the taking of property rights can constitute genocidal acts.
Certainly, taking property can create conditions of life that are intended to destroy a people, and that clearly is a violation of the law of genocide, but that doesn't mean that it's a violation of the law of takings. And this provision of the FSIA is creating a narrow exception for violations of the law of takings. There are other parts of the...
Thank you, Mr. Freeman.
Justice Gorsuch?
Good morning, counsel. I'd like to return to the question of what do we do about a stateless people. You indicated that the Jewish victims of the Holocaust were stripped of their citizenship but not nationality and are therefore still barred by the domestic takings rule. But if they can't access the domestic takings laws because they're no longer citizens, in what respect could that rule bar them?
Let me respond in three parts, Your Honor. First of all, the question of statelessness is not a question that was raised by the plaintiffs in this case in the District Court, Court of Appeals, or here. So this is entirely a forfeited question and one that the court need not address, and in fact hasn't been developed in any way. The second point is that, just to remind you, historically here, the claims are that this transaction occurred in the summer of 1935, which is...
Let's put aside the dates and the facts. Your third answer to Justice Alito supposed that they were, in fact, stripped of their citizenship before the taking, but that you said that doesn't matter because they're still nationals. And I'm asking you, well, in what relevant sense does that make a difference?
That would require this court to go down the path of determining the international law of nationality. I will say that there's no bad treatment exception under the international law of nationality, and if it were read, it's not the international law of takings is not a human rights principle. It's a principle of nation-to-nation rights and of the transfer of wealth. And in that sense, this would create an enormous expansion of the international law of takings if you viewed people who were stateless as being somehow immune from the ordinary rules of the international law of takings.
So the domestic law, taking law, as far as you're concerned, would permit a state to forbid almost everybody in its jurisdiction from any recourse, and that would pose no problem.
I mean, to be fair, Your Honor, again, this is not something that's been briefed, so I can't really say. I can only say that here, where there's no question that people were citizens and nationals, the international...
All right, last question. I'm sorry to interrupt, but the time requires me to do so. You say it was forfeited, but of course the plaintiffs won their subject matter jurisdiction on other grounds. If we were to find in your favor here, shouldn't they be given a shot to make this argument on remand?
I don't think so, Your Honor. I mean, they could have raised it at any point in response to our arguments that this was beyond the scope of the international law of takings. They never did. Matter of fact, even in their opposition brief here, they don't. They just point out that they believe that the rule shouldn't apply in the context of genocide.
Justice Kavanaugh?
Thank you, and good morning, counsel. Page 10 of your reply brief, you say, I'm quoting, "It is literally possible to read the exception to mean takings that violate any principle of international law," end quote. And to follow up on questions asked by Justice Sotomayor and Kagan, why isn't that the end of the case?
I mean, this court held in Samantar that the mere fact that something is literally possible does not mean it's what the text meant. And in Dolan, this court has noted that reading a statute to the outer limits of its definitional possibilities is sometimes an error. In the context of the FSIA, this court has made repeatedly clear that it's important to remember what Congress was going after. What Congress was going after was codifying the restrictive theory and avoiding friction in international relations. To read this to the outer limits of its definitional possibilities, to cut this phrase apart into different pieces and say it can cover this, is to create friction in international relations. It's to risk reciprocity in the ways discussed in the previous case.
Thank you.
Justice Barrett?
So, counsel, You said earlier that the expropriation exception, there would be jurisdiction for a U.S. court to hear a claim by a foreign national against, say, Germany, for a claim that Germany took that foreign national's property as part of the genocide of the Holocaust under the international law of taking. Judge Katsas pointed out in his dissent from denial of rehearing en banc that in the context of the kinds of claims that the plaintiffs asserted here, that the scheme they propose oddly matches the jurisdictional equivalent of a thermonuclear weapon, determining the scope of genocide, to the merits equivalent of swatting a fly, which is looking at the underlying merits, determining whether there was a common law conversion. Would, in the private context that everybody agrees could go forward under the international law of taking, if this were a suit brought by foreign nationals, would that involve the court same kind of quagmire that Judge Katsas is identifying here, having to determine the scope of a genocide, or does resort to the international law of takings give the court a clean way of deciding it without having to get into the rights aspect?
It gives the court the clean way, Your Honor, because the court just has to decide, was the claimant a national of another state, and then the basic parameters of the international law of takings. Was there compensation given? Was it prompt and effective? So it doesn't raise those kinds of extraordinary foreign relations concerns that are raised when district courts are asked to determine whether there's a violation of the law of genocide or systematic racial discrimination or the laws of war.
But it still raised the concerns implicated by a very, very large judgment against a foreign country?
Well, there's the possibility of a large judgment depending on the circumstances, Your Honor. I don't think the FSIA puts any limit on that except to preclude punitive damages.
Thank you.
A minute to wrap up, Mr. Fiven.
Thank you. I'd like to, raise three reasons for skepticism about the broad reading of A3 that plaintiffs provide. And the first two track what you heard earlier in Simon. Under plaintiffs' view of the expropriation exception, it's easier to sue a foreign sovereign than it is to sue a private defendant under the ATS. Because under the ATS, Kiobel makes clear that foreign-cubed cases don't belong in U.S. courts. The second is there's no serious account of reciprocity concerns. Those were laid out ably by counsel for Hungary. I need not repeat them. But they're extraordinary here when we're talking about subjecting a foreign sovereign to potential liability for the gravest human rights abuses in history. The third is clarity with regard to jurisdiction, especially for foreigners. In Helmerich, in the context of the expropriation exception, this court made clear that clarity is particularly important. In our view, it's there. It's the international law of taking. In their view, it's unbounded, any international law that anyone can think of in the human rights or law of war context.
Thank you, counsel. Mr. Kneedler?
Mr. Chief Justice, and may it please the Court, the United States deplores the atrocities committed against victims of the Nazi regime and has long had a policy of encouraging Germany and other countries to provide mechanisms to afford a measure of justice. Respondents, though, have sought to sue in U.S. court, but the exception to sovereign immunity on which they rely is limited to violations of the international law of takings or expropriations, which has long prohibited only the taking of a foreign national's property, if done without compensation. That interpretation is confirmed by the parallel provision of the restatement in effect when the FSIA was enacted, and the exception's statutory history as part of Congress's response to the uncompensated expropriation of American property by Cuba and others. By contrast, to read the expropriation exception as opening U.S. courts to suits based on human rights violations would constitute a major departure from the FSIA's text, structure, and context, and require U.S. courts to make sensitive judgments about a foreign state's treatment of persons within its territory.
Mr. Kneedler, you began by mentioning the United States policy of encouraging dispute resolution mechanisms to address questions such as the one before us. How do you judge the adequacy of those alternatives, and isn't that something that should enter into our determination about whether the takings remedy should be available under international law?
No, I don't think so. It seems pretty clear at the time that the only international law addressing takings was the law of expropriation, which had to do with whether compensation was awarded to a foreign national. So the question of any remedies between a state and its nationals was entirely internal.
Well, but that's the main policy, as I gather, of the United States, is simply to encourage other countries to provide mechanisms for compensation. And if that fails, then that's just too bad.
Well, under the international law of expropriations to which the FSIA was referring, that is right. The relationship between a state and its own nationals was a matter that other nations had no right to complain about. The domestic takings law is really the converse of the rule that international law does prohibit the uncompensated taking of the property of nationals of another country, because that violates the rights of that other country.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Kneedler, I'm interested in what you think of this, of the stateless people, or people who have been denaturalized, as Justice Alito brought up.
We have not addressed that, and that issue has not been developed in this case. And I don't feel that I'm in a position to address it here in this court. If the court thinks that it is worth focusing on or should be focused on, it would be open on remand to see whether that has been waived and what the ramifications are. But there are, perhaps sensitive questions about that, and I think the question would have to take into account the formulation of the rule, which is that international law prohibited the uncompensated taking of an alien's property or the national of another nation, and how that would play out, whether there's some other way to look at it with respect to stateless persons or persons deprived of citizenship. That is something that the courts on remand could consider if that issue has been preserved.
I know, but doesn't it draw into question, Mr. Kneedler, the difference in treatment between a citizen of a sovereign and the non-citizen of a sovereign, with the non-citizen, of course, being able to sue that sovereign under FSIA, but the citizen not being able to? And then the big question mark with respect to the denaturalized or stateless person.
Well, that question how that plays out has not been developed. But the reason why the national of another nation can sue is because the domestic takings rule, it is a product of state responsibility to another state, and an individual national of that state can sue for an expropriation. Now, how the loss of citizenship or deprivation of citizenship would play out within the expropriating country, something that has not been developed in this case. But
Justice Breyer?
This is a 30,000-foot question, so you may not have an answer. But in reading this, I thought, well, it's been for quite a long time that the United States has favored some kind of reparations for victims of all kinds of real horrors in the world: genocide, apartheid, slavery. We heard that the other day. And they still go on. Right. Certainly here, the disadvantage you point out of reading this statute the way you don't want it read. But we have not joined the International Court. It is more difficult for a private person to bring a case under the ATS, as now interpreted. Stuart Eisenstadt said these things should be worked out through informal mediation and other kinds of negotiations. I'm not sure if they've been done. So has it now turned that this is the only way? It's either nothing to deal with these problems and to get some kind of compensation, or we're left with our great efforts to have achieved almost nothing.
The United States for 20 years has been urging countries to adopt. First of all, right after the war, there were a number of reparations and compensation programs for victims. In more recent times, starting with the Washington Principles, the United States has been a leader in urging other countries to establish their own mechanisms for the restitution, tracking down and restitution or compensation for property that has been taken. Different countries have responded, some more fully, others less so. The United States continues to urge and work with those countries, particularly Germany. There was a joint statement issued in 2018 in which the United States recognized that more needed to be done with respect to the advisory commission that Germany has set up. There are questions about whether remedies would be available in German law. The Washington Principles rest on an understanding that different countries may have different approaches to these questions. Some could be lawsuits, some could be mediation panels, arbitration panels, things like that.
Justice Alito?
We've talked about the stripping of citizenship. What about the acquisition or the forced acquisition of citizenship? So was a Jew who lived in Austria barred by the domestic takings rule after Germany forcibly annexed Austria? What about a Jew living in the Sudetenland, for example?
Well, I think there could be questions about who was the government of that territory at the time. Was there a Vichy government that would be the responsible government, or was it directly governed by Germany? So there could be questions like that would involve questions, not directly involved here.
Yeah, no, I understand. Perhaps that's not a fair question to require you to respond to, but I think this is. Could you address the question that I asked earlier about the definition of a covered period in the 2016 Clarification Act?
Yeah, I think it's important to recognize that what the 2016 Clarification Act did was really preserve the ability of someone in that who had a claim in that covered period to rely on the loaning of property for the commercial nexus. It left untouched whether there was a violation of international law and what that term means. It really, rather than bringing those claims within the immunity that was granted under that special statute when property was brought into the United States, it accepted these claims for that period from that new immunity, but it left them otherwise as they were. Therefore, it's necessary to go. And Congress was being comprehensive by including the entire period of the Nazi regime, so that all those claims would be able to take advantage of that jurisdictional nexus. But again, it left untouched the question of what taken in violation of international law means. In fact, it specifically refers.
Thank you, Mr. Kneedler.
Justice Sotomayor?
Counsel, to what extent have other nations created or done away with sovereign immunity for takings either from nationals or non-nationals? Meaning, the U.S. has done it, you claim, for takings involving non-nationals, but how many other countries have done the same thing? Waive sovereign immunity in those situations automatically?
Virtually none, and certainly none have waived with respect to claims or abrogated or created an exception for claims based on takings from domestic takings.
Well, I guess if, to me, I'm sorry for interrupting you, but we're on limited time. If we're already an exception to the rule, I don't see then why we have to read the exception to the rule, what the principles that would guide us with respect to the U.S.'s self-interest. Why we shouldn't just read the plain text of the law and import into it the limitations of customary international law when customary international law, frankly, doesn't waive sovereign immunity at all.
Well, this was a very modest exception when it was adopted. It was intended to be, and it was an outgrowth of a piece with Congress's efforts to respond to the uncompensated garden variety, or whatever you want to call them, the regular sorts of takings that are governed by our just compensation clause, and are governed by the customary international law of takings or expropriation. It was regarded as not much of a deviation from the restrictive theory of sovereign immunity. What's being urged here would be a radical departure from that, because it would open U.S. courts to adjudicating whether foreign governments had engaged in serious human rights abuses. Here it may be, everybody agrees that there was a genocide and that a human rights violation occurred. And in response to that, in fact, that's what the United States has urged the countries involved to be responsible for. But in other situations, the court might be asked in the first instance, to decide whether there was an Armenian genocide, for example.
Thank you, counsel. Justice Kagan?
Mr. Kneedler, I take your point that Congress probably wasn't thinking about this case when it passed A3, but that's not always what we consider most relevant. I mean, what is your best evidence that this language that is used in A3 is a term of art with a specialized meaning, as opposed to ordinary language that should be read in an ordinary way to comprehend these claims, whether or not Congress thought about the question at the time?
Well, I mean, I think there are a number of things that reinforce that. First of all, the entire phrase is taken in violation of international law, which requires reference to international law as it was understood at the time. And the restatement at the time, Section 185, and this court has looked to the restatement in the past to inform its understanding of the FSIA.
Well, international law at the time recognized the international crime of genocide, correct?
Yes, I'm sorry, but in 76, yes. But I think what's important to look at is the phrasing is property taken, which we think connotes or calls up the concepts just like in our own Fifth Amendment, referring to property taken.
I mean, it's true that you have the word taken, but in fact, you don't even have the word taking or confiscation in the way that you have in the Hickenlooper Act. And the restatement, which some people have pointed to, it also uses the word taking and makes it very clear that the word alien is all over the restatement. So if I'm just looking at this language taken itself, I say, well, this language covers these claims.
Well, again, the reference, the Section 185 of the restatement posits the question when taking is wrongful under international law, which is virtually the language of the exception. And then it says the taking by a state of property of an alien is wrongful under international law in the specified circumstances. And this is a position that goes back to Secretary Hull in 1938, to Belmont, to Sabatino. Controversy in Sabatino is whether...
Justice Gorsuch?
Good morning, Mr. Kneedler. I understand your argument that the Clarification Act only works to address limits on the commercial activity requirement. But H2 does exempt Nazi-era claims, where the action is, quote, based on a claim that such work was taken in connection with the acts of a foreign government as part of a systematic campaign of coercive confiscation or misappropriation of works from members of a targeted and vulnerable group. Doesn't that seem to anticipate that there will be such claims that can be brought under A3?
I think what it does is recognize that some such claims have been brought, but it doesn't pass on the question of whether they are valid claims. It serves the purpose of not granting those claims an additional immunity, in a sense, by saying that if the property is brought in to the U.S., it doesn't count as commercial activity. But it otherwise refers to a taking within the meaning of B3, and that refers back then to what A3 means. And we think it was clear then and is clear now that it is limited to the international law of expropriations, which has to do with whether there was adequate compensation and a public purpose.
If Congress, though, isn't disadvantaging Holocaust-era claims the way it wishes to disadvantage other claims. What should that tell us?
That there was I suppose, special solicitude in in not cutting off those claims. Again, it only applies when the property is brought into the United States. And if Congress was acting on the assumption or even the belief that some claims were valid, that still is the view of a later Congress. It didn't change the language, and this court has often said that the view of a later Congress is of very limited force when it comes to interpreting something that was enacted here almost 40 years earlier. And again,
Justice Kavanaugh.
Chief Justice, and good morning, Mr. Kneedler. You've explained what you think the statutory phrase means, but I just want to explore the rationale behind the distinction. So what, in your view, is the justification for denying compensation to citizens of the country in question, or maybe stated the other way, what harms would result from recognizing claims that outweigh the benefits of recognizing claims?
Well, several things. It's an aspect of the rule of state responsibility to other states. And so when the expropriating state takes the property of another state's nationals, that is offending the rights of that state, and that individual, Congress concluded, should be able to sue. But corresponding to that, this court has often said in Sabatino and elsewhere that that principle is limited to the taking of property of aliens because, as a general principle, the treatment of a country of its own nationals is not a matter of international concern. So what was and if a state, and this was true in communist states, this was the controversy at the time. So many states believed that they could take their citizens' property without compensation. And the active state doctrine and Sabatino did not interfere with that at all. All of those cases and discussions took as a given that there would be no compensation, or the U.S. could not enforce a rule of compensation for an expropriation by another country of its own nationals' property. That was a given. The controversial point was the one the United States was urging about whether international law even spoke to the question of expropriating the property of nationals. And the restatement and the expropriation exception are an expression of Congress's view of U.S. policy. Yes, that does violate international law, but that's as far as it goes, and that is what Congress was driving at in enacting the FSIA, not opening U.S. courts to broader human rights violation claims.
Thank you, counsel. Justice Barrett.
Mr. Kneedler, I have a question about what the Clarification Act tell us about the expropriation exception. So in showing special solicitude for Nazi-era claims, the Clarification Act clearly assumes that some such claims against Nazi-era confiscations of property would be going forward, and that the Foreign Sovereign Immunities Act would not bar them. So if your interpretation of the expropriation exception is correct, say that it applies only when there's a foreign national suing a government for the taking of property, what kind of class of claims are those? I guess that would open up some of the difficult questions of nationality and citizenship that Justice Alito was asking. But could we expect there would have been, or was there, a large subset of claims brought against Nazi governments, Nazi-controlled governments by foreign nationals? What is Congress referring to there?
Well, several things. I mean, like Altman was a case by a foreign national against Austria. But I think the bigger point is that Congress knew there were such claims, but I don't think that is the same thing as Congress determining that they fell within the Expropriation Act. And in fact, again, the Clarification Act simply refers to the taking of property within the meaning of A3, which refers one back to what A3 means. So really what Congress was doing was not taking away the opportunity of someone who had such a claim to rely on the loan of property to a U.S. museum as establishing the commercial nexus. But it didn't do more than that. And I think the court should insist upon a much more explicit and conscious determination by Congress to open up U.S. courts to these sorts of claims which are far beyond what Congress had in mind when it enacted the FSIA.
Thank you, counsel.
A minute to wrap up, Mr. Kneedler.
Thank you, Mr. Chief Justice. An important thing to remember here is that the Foreign Sovereign Immunities Act was a codification of the restrictive theory of sovereign immunity, and it adopted a general rule of immunity subject to exceptions. This court has referred to that as a presumption of immunity, and this court should enforce that by insisting upon a clear statement by Congress to depart from the restrictive theory. The problem here, beyond the statutory text and context and background and structure, is the fact that this would put courts of the United States in the business of making sensitive judgments about the conduct of foreign governments, including perhaps some of our closest allies, and invite other countries to open their courts to claims based on situations in this country's unfortunate past, where it has committed acts that everyone would now regard as violations of the law of nations. So this court should adhere to Congress's understanding and intention of limiting the expropriation exception to circumstances involving the taking of property by foreign nationals in the traditional sense of requiring the compensation and not tied to the violation of international law.
Thank you, Mr. Kneedler. Mr. O'Donnell?
Mr. Chief Justice, and may it please the Court, the Foreign Sovereign Immunities Act provides jurisdiction over cases in which rights and property taken in violation of international law are an issue. The ordinary and natural meaning of that phrase, chosen by Congress, applies to petitioners' property takings during the Holocaust. The Nazis deemed German Jews to be non-German, aliens outside of the rule of law at the moment the regime began on January 30th, 1933, and took their property because of who they were. I was puzzled to hear the suggestion earlier that we have not raised that issue because we have framed the case in those terms since the complaint and at every stage since. This court in Helmerich noted the potential that a sovereign's takings of its own national's property may amount to a violation of international law. If that logic did not apply to Nazi forced sales from Jews, when would it apply? Petitioner Germany also committed genocide, which is itself a violation of international law. The Nazi government set out explicitly to destroy the German Jewish people by taking their property, and Congress has specifically identified the Nazis' looting of art from the Jewish people as genocidal. This is not a new kind of human rights case. It's a property rights case. Briefly, with respect to comity, sovereign immunity is the broadest expression of what Justice Breyer this morning called a motivating principle, and Congress in 1976 created a comprehensive, non-discretionary framework for that motivating principle. Petitioners' newfound status-based comity abstention argument would trample the FSIA out of existence. As Ms. Harrington said, what sovereign defendant would not claim a paramount interest in property within its own territory? Every one of the takings of property of aliens that petitioners say are covered by the law would immediately face this assertion. Congress has set the rules, and the court need not rewrite them.
Counsel, what do you do with the International Court of Justice determination that it would, in fact, be a violation of international law to refuse to grant immunity to a state for expropriation of its own nationals' property?
Mr. Chief Justice, I think the answer is one that Ms. Harrington provided and that Mr. Kneedler in part conceded, and that is that there is no other nation that provides jurisdiction for expropriations in this way. So if the expropriation exception would violate international law, it already has, and it already has for almost 45 years.
So what is your best evidence that there is a genocide exception to the general rule that the expropriation exception is limited to taking of foreign nationals' property?
Mr. Chief Justice, I think there are two answers to that. One is that, as was alluded to in an earlier comment, genocide was already recognized as a violation of international law in 1976, and much more squarely.
But at that time, the expropriation of a nation by its own nationals' property was not recognized violation of international law.
I think, respectfully, Your Honor, that the state of that understanding is a little less solid than petitioners suggest. I think one of the things you see in the congressional record, you see in the amicus brief by Mr. Feldman in the Hungary case, for example, is that it was a bit of a jungle. as to how to treat expropriations from citizens. And the restatement addresses when a taking of property from an alien violates international law, but it's a section about takings from aliens. And it's not as clearly laid out as the Genocide Convention, which had been codified all the way back in 1948 and was well within the view of Congress. And the second is, this specific historic episode had received considerable treatment by U.S. policymakers and the executive. In particular, the letter from Mr. Tate in 1949, that it was the policy of the executive, never rescinded since, to remove any constraint upon the exercise of jurisdiction over the acts of Nazi officials.
Well, obviously there's no issue in this case, but how do you decide in other instances whether or not the taking is in the context of more general violations of human rights, so that you fall within this? In other words, how broadly would you articulate the, if you want to call it the genocide exception to the normal rule? Now, of course, the first answer is, whatever it is, it covers this case. But do you have a more general rule that would be applied in other situations?
Your Honor, I have two. The first is when the claim has to sound, as you said in OBB, the gravamen has to be about the taking of property. And if you look at the other human rights norms in Judge Katz's dissent, for example, they do not implicate the taking of property. Torture is not caused by the taking of property. In fact, the Torture Victim Protections Act specifically eschews torture by deprivation of anything or caused by anything other than physical anguish. So the first is the claim that the international human rights norm has to sound in the taking of property in the first instance, and those other norms do not. And the second position I would say, Your Honor, as the final sort of boundary against all of this is, well, then look to what Congress has said. Has Congress recognized this episode of property taking as a violation of international law or as genocide? That list is vanishingly small. And even those instances that Congress has recognized as genocide after considerable debate, fewer of those still, again, the Genocide Convention has multiple avenues, if you will, to the commission of genocide.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, can you give me any example of genocide where property has not been involved? It seems like, as I think of whether it's Armenia or the Ukraine or Germany, or up in the Baltic states, that whenever that's occurred, there's been a loss of property or a taking of property. So wouldn't virtually every one of those be covered by your argument?
Not necessarily, Your Honor, because even those genocides recognized or commonly understood, recognized as such, again, there may be property takings that happen alongside the genocide, but the Genocide Convention, genocide can be committed, as I've said, in multiple ways. And if you kill the members of the group and then you take their property, the taking didn't cause the genocide. It was alongside of it. But if you take the property, as Germany did, explicitly to destroy the group of people and remove it from the face of the earth, then you committed genocide through the taking of property, which is the focus of the expropriation exception.
Well, I don't understand how it would make a difference to have one sequence versus the other, that you commit the genocide before you take the property, or the property before you take before you commit the genocide. But with that aside, we've said, I think, in other cases that the expropriation exception was not a radical departure. Wouldn't your reading it as you do be just that, a radical departure?
With respect, Your Honor, no, because I would submit that if there was any taking of property recognized in 1976 as in violation of the law of nations, it was what this petitioner did between 1933 and 1945. It is not hard to imagine at all. In fact, I think it's the opposite.
Well, I understand that, but I'm talking about your reading of FSIA. Wouldn't that be a radical departure from a more restrictive theory?
I don't think it would, Your Honor. It would be a departure from the restrictive theory, no question, or from the restrictive theory as it appeared, but that view changed over time. And again, I come back to the author of the letter that announced the restrictive theory in 1952, and that's Mr. Tate. And genocide in this way, we can be thankful there are not other examples like it. It cannot be repeated enough. There is no paradigm like the Holocaust, and there is no second case that fits into the allegations of the Holocaust. Messerhain, the 11th Circuit case relied upon by petitioners, points this out. The Venezuelan victims in that case tried to say, well, we are sort of being treated unfairly and like foreign nationals, like the Nazis treated people. And the 11th Circuit said, that's absurd. That's absurd. There's only one Holocaust.
If we have some doubts about whether or not you preserve your alternative standing argument, should we just remand that to the district court to consider in the first instance?
Alternative standing in what respect, Your Honor?
Well, I mean, if your argument, you're arguing obviously an interpretation of FSIA, but you also have an argument that you just made, for example, that genocide, that the taking is genocidal. Was that preserved?
Yes, Your Honor. We allege in the complaint, and have said at every stage since, that Nazi Germany's treatment of the consortium as non-Germans is a violation of international law. The petitioners raised the domestic takings rule in their motion to dismiss the First Amendment complaint, and we have been arguing about it ever since. I really don't understand petitioners' argument that this has not come up before.
Thank you.
Justice Breyer? It seems to me that you could read this language to refer to what was expropriation. That was the communists, that was Nasser, that was sometimes in South America, Venezuela, etc. And they're talking about expropriation. And the other way would be to read it as you read it. They're just talking about property involved in a violation of international law. And as Justice Thomas, as I pointed out, seems to me there are loads of violations of international law in violating that involves property, not just genocide. And so an argument that's made against your side is, look what you're opening up. I mean, you can have slavery involving property. You can have systematic discrimination. You can have cruel and unhuman degrading treatment. I mean, the list goes on of what violates international law. And many of them involve property. And if we can bring these kinds of actions here, well, so can these other countries do the same and accuse us? I mean, what about Japanese internment, which involved 30,000 people in World War II who were not American citizens, but were of Japanese origin? And the first time we sued China for the Rohingyas or whatever, what do you think they're going to say about the railroad workers who came in the 19th century? I mean, that seems no way to limit it according to a principle that would say we should have the actions here that are universalizable and won't hurt through chaos if they're brought everywhere. Now, that's a fairly strong argument. And so I think, but that's why I want to hear you answer it.
Your Honor, I think the first response to that is that it could easily be limited to instances where Congress has identified the episode or the taking in those terms. And again, that's a very short list. I don't know that it extends any further than the Holocaust and World War II.
Well, why isn't it? Why isn't it a taking of property in violation of international law where in country X they have child slavery involving children from other countries, and they take the property. Indeed, whether or not you call it labor as a property, they take other property too. And so they come to court, and 700 judges in this country pass judgment on that. Why doesn't that fall within the language?
Because the violation of the international norm, Your Honor, doesn't cause the deprivation.
Why it doesn't? Doing them into slavery, bringing them into slavery, doesn't cause the deprivation of the house they owned in the adjacent country? It doesn't involve the deprivation of sometimes their clothing and sometimes their gold teeth, as Justice Thomas said. I mean, terrible things happen in this world. And that's why I was somewhat moved by Eisenstadt's statement that the way to go after them practically is through all kinds of mediation, arbitration, and other kinds of special agreements, and not necessarily 700 judges.
Well, Your Honor, I'll take that second point first because, as Ms. Harrington alluded to, I think it's actually the reverse. The existence of those claims is what led to the Berlin Accords and the resolution at a broad level of banking claims that were substantial and sweeping. And it was the prospect of facing those litigations that brought the parties to the table. In this case, Congress has recognized, sure, it's better that we can work it out, but it's clearly not possible. That's what the HERE Act says. Congress stated a strong, unanimous policy in 2016 that these claims survive. Again, to go back to the Clarification Act, if Congress has recognized it, there really isn't a need, I think, for a further inquiry.
Justice Alito?
I want to make sure I understand the scope of your argument. At times in your brief, particularly when you refer to the absence from the provision in question of any reference to aliens, you seem to be making an argument that would apply to any domestic taking. But that's not your argument. Am I right?
No, it would still need to violate an identifiable norm of international law.
Okay, so is it your argument that any taking that violates any principle of international law would be covered, or is your argument limited to those acts that constitute genocide or those that are part of a campaign of genocide, or is it a Holocaust-specific argument?
My argument, Your Honor, is it extends certainly to genocide, it extends certainly to the Holocaust, and it would extend to other norms of which I can't think of any, where, as I said to Justice Breyer, it is the violation of the norm itself that causes the property taking. Well,
since World War II, customary international law has expanded greatly. Prior to World War II, it was largely, if not entirely, limited to relations between nations, but in reaction to the Holocaust, to those horrors, customary international law has reached out and now protects many human rights. So would your argument apply to any taking that violates any principle of human rights recognized by customary international law or by treaties since the Second World War?
No, Your Honor, it couldn't extend any further past 1976 because the court has said on a number of occasions that the understanding for this law...
Well, most of that work was done. A lot of it was done before 1976. Would it include everything recognized up to 1976?
Your Honor, I'm not sure I have the same view of how much of that work had been done by 1976, but if the norm violation caused the property taking, yes.
But even if it's limited to genocide, there have been many incidents in the past that some people claim are genocidal. Sometimes these are hotly disputed. I won't go through the list. I hope there won't be more in the future, but given human nature, that's a possibility. Wouldn't your argument require courts to decide whether a particular event that indisputably involves atrocities amounted to genocide?
They might be faced with that threshold question, Your Honor. And in that instance, as we've said, I think the easiest signal post, as in the rest of this law, is to look what Congress has said about that alleged episode.
Well, on what ground would we say this includes genocide, but only those that have been specifically recognized in some other statute that does not govern this particular case? What would be our justification for drawing that distinction?
It would be to determine the scope that Congress intended through the passage not only of this law, but of other laws on that topic as to that particular case. Now, in this case, the FSIA itself has been amended to include the episode at the heart of this very case.
So did the meaning of the FSIA change based on later congressional legislation?
No.
And how would we read that back into our interpretation of the FSIA?
Well, then, I suppose, Your Honor, you'd have to look at those genocides that Congress had recognized as of 1976.
So this would apply only to past genocides? It wouldn't apply to any that occurred in the future?
No, I think I would walk that back, actually, Your Honor. I think if Congress expressed itself squarely in those terms, it would apply.
All right, thank you.
Justice Sotomayor?
Counsel, let's assume we accept your adversary's position that the SIA has to be read to apply, that the only international law was the customary international law that limited its application to non-nationals. Just articulate for me what you see as left in the case. Do we reverse and direct dismissal? Do we reverse and remand, and for what?
Your Honor, I think you affirm, because the complaint...
I know that's what you want, counsel.
Right.
I just said we don't, if we assume your opposition's position, what would you ask us to do then?
As applied to the allegations of German residents specifically in our case? That you hold
as to your case, he wins. He presented a question. We say he's right, that customary international law does not apply to the takings of nationals. That's the rule we set. What's left of your case?
I suppose, Your Honor, that what's left is a remand to determine if under a relatively unaddressed part of the case in terms of the scope of nationality, a remand to answer that question, whether in this case, as amici have ably demonstrated, that German governmental treatment of German Jews in the 1930s would transgress that nationality line. I think the answer is clear, but the court may determine that it hadn't been addressed below and needed to be.
All right. One of the things that I'm dealing with in my own head is how would we determine, I know the amici make their argument, but given that there hasn't been a recognition of causes of actions against sovereigns in other countries for expropriations of property within the borders of a nation, how will we ever determine that question? How can we ask the court below to determine that question outside of an academic discussion?
Well, I think that's a question of fact in a particular case. I mean, and it may require the submission of historical expertise.
Thank you, counsel.
Justice Kagan?
Mr. O'Donnell, Judge Katsas, in one of his dissents, made the point that your position would create a kind of strange dichotomy whereby victims of the Holocaust could bring suit for property deprivations, but their relatives or could not bring suit for their deaths. So why would that make sense?
Justice Kagan, that dichotomy already exists even in the classical expropriations that petitioners assert are the limits of the law. And I'll give you an example. Let's assume that someone in Venezuela had been tortured by the Hugo Chavez government. That person could not sue under the FSIA. That person was a foreign national. That person could not sue under the FSIA, but they could sue if the Venezuelan government took their property. That's a dichotomy that Congress has factored into the exception itself.
Go about the text a little bit here. What more do you think Congress would have had to say to limit it to sort of standard international law expropriations?
I think this goes back, Your Honor, to the term of art question. And I think maybe if Congress had said concerns rights and property or concerns takings in violation of international law, I think this goes to your questions earlier, and a question you posed in the Helmuth oral argument. They could have phrased this in a different way that more obviously implicated a body of law. I think petitioners suggest...
Is that slicing the salami pretty thin, taking versus taken, when we know what they were talking about, really?
I don't think so, Your Honor, because again, to be a term of art, it has to be specific and has to be used similarly elsewhere. Even this phrase doesn't appear in the Second Hickenlooper Amendment. The words international law do, but the context, as petitioners would put it, around that phrase is slightly different. And so if Congress is using slightly different words, we must assume that it had a slightly different intention.
Maybe we should forswear the kind of ordinary meaning textualism that you are asking us to adopt in this context. Mr. Needler said, we've long understood that the FSIA codifies the restrictive theory of sovereign immunity, which, except for narrow exceptions, gives the foreign sovereign immunity for public acts. So why, in that context, shouldn't we be thinking a little bit more than we typically do about actually what Congress had in mind when it drafted these exceptions?
Well, I think, Your Honor, certainly a plain textual interpretation has the benefit of simplicity. In this case, if you are interested in the context and you look to the legislative history, which I urge the court to do, first, in the 1973 hearing, Hitler's takings of art came up specifically, as well as did other various contexts like the taking of Lithuanians' property, that make clear that there's no limitation in mind. Again, this was a fairly expansive discussion, both in terms of the hearing and the back and forth. And as you said earlier in this argument, of aliens is all over the restatement. And it's not, in this case, that the lodestars are taking without adequate and fair compensation, not for a public purpose. That's arbitrary or discriminatory. And it would have been very easy somewhere in those hearings, let alone in the law itself, for someone to say, but of course, we're only talking about the property of aliens. And they didn't.
Thank you, Mr. O'Donnell.
Justice Gorsuch?
So, Mr. O'Donnell, I understand that if Congress had said, use the word taking rather than taken, you'd admit you'd have a much harder case.
I think we'd have a harder case, yes.
And that's because taking is a term of art and taken is not.
I don't know that I agree that taking is a term of art, Your Honor, but I think it's a lot closer to one. And it's a sort of term like those that appear in the cases cited by petitioner, prevailing party, costs, substantial evidence, things that are recurring terms in the law.
What do we do about the fact that the statute uses the word taken? The then restatement spoke of international law takings in violation of international laws in the manner that your opponents suggest. This remained true despite knowledge of the Genocide Convention and the Hague Convention, which would have contained language more like what you're asking us to read into the statute. Then you've got the Hickenlooper amendments as well. And that's all before we even get to some of the other statutory clues that Judge Katz has pointed out. Why doesn't that, as a matter of ordinary meaning at the time of the statute's passage, stand as pretty strong evidence against you taken collectively?
Because those elements of international law, Your Honor, are restrictive and not defining. The restatement second, Section 185, is in a chapter entitled Taking of the Property of Aliens. So the fact that taking of the property of aliens violates international law does not mean that is the extent of international law. And the Sabatino-Hickenlooper Amendment bears this out because the second Hickenlooper Amendment refers back to violations of international law, including those in this section. And those in this section are takings from United States citizens. So it is exemplary but not exhaustive.
Okay, and then if your contrary reading were correct, I think you've agreed that property takings, or taken, if you will, because of a genocide is not going to be the limit of our jurisdiction. It's also going to include any other human rights violation norms that somehow are related to property. I would have thought terrorism, slavery were a couple of examples we've batted around.
Good afternoon, everybody. I want to, rather good morning. Forgive me, we started the day a little bit early because the California legislature is back in session today, and we wanted to be respectful to their respected new celebration that is always December 7th in a year where we have new members of the California legislature. So I'll just jump right in, try to be as brief as possible, get to a number of the issues of the day, particularly as it relates to some of the regional orders that now are in effect in the state of California, but also wanted just to provide some of the regional orders and information in effect in the state of California, but also wanted just to provide some context and some information about some new technology that we're bringing to bear to slow the spread of COVID-19. There's been a lot of discussion around apps. There have been a lot of discussions about how technology can advance our efforts to notify individuals, mitigate the spread of COVID-19, and address this pandemic head-on. Two of California's best-known headquartered technology companies, Google and Apple, have joined together in an effort to provide for exposure notification, not contact tracing, but exposure notification. I want to provide you a little bit of information about what California is doing today to help support their efforts, a little bit about the work that we've been doing with Google and Apple over the course of the last number of months with a pilot program, particularly at our UCs. But you can see here that the California Notify app we're putting out is about an opt-in opportunity for individuals to participate in a notification protocol, an opt-in, not an opt-out, privacy protected. This is not contact tracing. Notification technology. You can choose to participate in leveraging this technology to allow people that you have been in contact with or have been in contact with you to be notified of potential exposure related to the transmission of this disease. I remind you, it's 100% private, 100% secure, 100% voluntary. You opt in or you choose not to, and there is no tracking data, no location data that is shared as parcel of California Notify whatsoever. These are foundational principles. The reason I'm reinforcing them is because they're important. We value privacy. California has long been a leader in terms of advancing the cause, and we don't want to do anything to set that cause back. And that's why we've been, frankly, a little stubborn and kept our eyes wide open in terms of this technology. We didn't want to jump in ready, fire aim. We wanted to really take time, reflect on this technology to be secure in our confidence that what we are promoting, what we're stating here today, is indeed accurate, and that's exactly what we have been doing. Now let's talk about the technology specifically. Technology will be available this Thursday. You have two platforms. You have the Apple and the Google Android platform. The Google Android platform requires that you download California Notify from the Google Play Store. You open up the app, you turn on the COVID-19 exposure notification. It's a very, I don't say relatively, it is indeed a simple process. Go, if you have Google Android, download the notification app from Google Play, and you open the app and you turn on the notification. I'll tell you what it does in just one moment, but I'll remind you it's available this Thursday. The Apple iPhone, right here, it's a simple thing. It's already in the phone. You open up settings, you scroll down to find the notification. You can see there on the slide specifically what is required in terms of the prompt. You just tap the turn on notification for exposures, and you follow the prompts. It allows fundamentally Bluetooth access, and you just have to always, as the case with these technologies, just accept the terms. Now you tap turn on, and that's it. Your phone now is prepared for a notification. But let's talk about what this is. Here's how it works. So let's assume you are Alice and or Bob. You're chatting. You're very close. You're not socially distanced. You're not physically distanced. You're chatting for a number of minutes. And your cell phones, because you have opted into this technology, are automatically, because of Bluetooth, exchanging what we refer to in technology.
Maybe a category that violates international law. And I think, again, as to what would have been understood in 1976, I know I keep talking about my case, but this episode, of course, was the paradigmatic episode of taking an international law violation in 1976, and I think it would have been well understood by that Congress, I looked this up in the congressional historians, 40% of whom had served in World War II, as had the president. I think, to pose the inverse of a question the court I think Justice Alito raised in his post hoc dissent, I think the Congress would be shocked in 1976 to hear the suggestion that Nazi Germany's property taking didn't violate international law for the whole of the regime.
Thank you.
Justice Barrett?
Counsel, the distinction that you're drawing between taken and taking seems awfully thin to me, because if I'm looking at 1605A3, the way that it's drafted, I mean, one could say with reference to our takings clause, in which rights and property taken in violation of the takings clause or in violation of the Fifth Amendment. I mean, moreover, when you go to the Clarification Act, it does use the word taking. And referring back, I'm looking now in H2E. You look down into the subsections, it talks about the taking having occurred after 1900. So the statute does use the word taking, and the way that 1606A3 is drafted, it would be hard to say anything other than taken. So really, does your argument depend that much on the distinction between taking and property taken?
No, Your Honor, and if I can clarify, no pun intended, Justice Kagan asked me about what other word might have led to a different result. I'm not arguing that that taking would dispense with the claims, but certainly, and this goes to a question that Justice Alito raised earlier, the Clarification Act, taking or taken, refers to the whole of the regime. And it would make no sense, this just comes back to the textual principles that I talked about before, it would make no sense to encompass that whole era if it meant to exclude a certain category of takings in a certain date range that Congress didn't say.
But Mr. O'Donnell, a lot of the force of your argument depends on the ordinary meaning of the terms and relying just on, property taken in violation of international law rather than saying it in a term of art way. But at the same time, you've pointed to all kinds of limitations that might exist outside of that ordinary meaning of the text. For example, this is just genocide or just if Congress calls it genocide. Can you identify some of the limiting principles? So you said maybe this is just the Holocaust, the Nazi Holocaust, maybe this is just genocide, maybe it's just genocide if Congress identifies it as such. Are those the only limitations you might find in that text?
Your Honor, I think the plain meaning of the phrase is the starting point. Is the episode in the hypothetical case number 2, does it put rights and property taken in violation of international law in issue? Right? Are those things in play? And if you read that and look to the episode in question, you don't have to limit yourself. I'm not saying you have to limit yourself to the text and learn nothing else from other words or context. I'm not saying that because, of course, I think the context supplies the answer as well. And in that hypothetical case, you would say, what is it about this episode that did or did not violate international law?
But counsel, it's very difficult to see in the examples that Justice Gorsuch is giving you, for example, how property taken in the course of enslaving people wouldn't fall into this very same logic that you're articulating here. I think you're struggling to identify limits because you know that it's problematic to interpret it so broadly that it would have 700 district judges in the country adjudicating all these kinds of claims.
Well, but I think the limiting principle, Justice Barrett, remains the taking itself. Was the property taken in violation of international law? And that assumes that the norm you're talking about was breached through the deprivation of the property itself.
Thank you, counsel. I'm out of time.
Counsel, you can take a couple of minutes to wrap up if you'd like.
Thank you, Mr. Chief Justice. Petitioner's argument boils down to this, that despite the absence of language in the FSIA as originally passed that would limit claims based on the nationality of victims of government property takings, and despite the presence in the Clarification Act of language specifically recognizing the full extent of the Nazi regime's art looting and forced sales as properly within the expropriation exception, that unique among Nazi victims, Congress intended to disadvantage the Nazis' first victim, German Jews. This makes no sense. With regard to comity, which I know we have not spent much time on, I would say the FSIA says to district court judges, the defendant is immune unless an exception applies, and I think in this circumstance of the game of baseball, the judge in that scenario can be thought of like the umpire in the baseball game, whose rules say the batter gets 4 balls or 3 strikes, creating a status-based new comity abstention doctrine to avoid the FSIA would be like telling that umpire that even when the batter strikes out, the umpire can still award first base if the batter is important enough or really wants to get to first base. But to do so would be to legislate where Congress has not. Thank you.
Thank you, counsel. 3 minutes for rebuttal. Mr. Fryman.
Thank you, Mr. Chief Justice. A couple of small points, and then I'll wrap up. First of all, the Clarification Act. I think it's important to remember that it only involves art that is physically present in the United States. That's a consequential distinction when we're talking about foreign sovereign immunity. Second of all, with regard to what to do if you find that the expropriation exception applies only to violations of the international law of takings, this is not a situation where remand is appropriate. The plaintiffs have never claimed that the consortium or the firms or their ancestors were not German nationals. You won't find a paragraph in any of the briefs at any stage of this litigation. This is something that should be resolved finally here. In sum, the court's been given 2 literally possible meanings. Ours is consistent with the background that Congress was legislating against and with the understanding of the term taking in violation of international law as it was understood in the restatement, which this court has used to understand FSIA exceptions in the past. Even if the plain text doesn't decide, you should look to the canons, and all of them cut in our favor. I'd like to highlight 3 of them. First of all, clarity. In Helmerich, this court held that clarity in jurisdictional statutes, especially regarding foreign sovereigns, is particularly important. It's a doctrine with enormous diplomatic consequences, and Congress knew that clarity was important. It didn't create an exception letting foreign sovereigns be sued for sovereign acts without knowing the boundaries that it was legislating. Under our interpretation, Congress knew them. International law of takings, doctrine that the U.S. had long advocated for with a specific content and coverage. Under the plaintiff's interpretation, Congress didn't know the boundaries. It was any principle of international law. That's a big set, one that can keep changing. Congress didn't want to lose control of a sensitive diplomatic area like this. Second, their reading would ignore judicial interpretations of the very similar language of the second Hickenlooper Amendment. And there's no doubt that Congress knew of that. The statute was cited in the committee report here, as was a case by this court, Alfred Dunhill, repeatedly citing the prior judicial interpretation of the second Hickenlooper Amendment just a few months before the FSIA was passed. Third, their reading would violate the international law of state immunity and rip a large hole in the restrictive theory that Congress was codifying. My friend tries to limit the consequences to genocide, but the Genocide Convention doesn't use the word takings or taken. And as several members of the court have noted today, slavery, systematic racial discrimination, and other norms like crimes against humanity or the laws of war can all involve takings. Almost 700 judges, as several of you have noted, would sit as new world courts, judging the nations of the world for alleged violations of international human rights and the law of war. Much more should be required from the text to reach this result. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.